May I just briefly tell you the facts to show how both the parties are concerned and are deeply involved with the contract itself. Now, the first issue is that there were four contracts between the parties. One is the software license agreement, sub-license agreement. One is the general terms and conditions of contract. And there are two forms for actually carrying out the order. So may I just first and foremost take your lordship to the agreement itself for the software license, my lord. And if your lordship will see on page 33 of the paper book, under the heading proprietary information, means with respect to SAP and SAP AG, we are trying to ask that both parties be joined in the arbitration, my lord. The license or the SAP proprietary information to SAP, the software and documentation, any other third-party software licensed with or as part of the software benchmark results, manuals, programs, dates, structures, flowcharts, logic diagrams, function specifications, the concept, techniques, ideas, and know-how embedded in expression software, and information reasonably identifiable as confidential and proprietary information of SAP or licensee or the licensor, including any part of the SAP of licensee proprietary information, which is or part becomes publicly available through no act or failure of the other party, or originally acquired by the other party from a source other than the disclosing party, becomes independently available. So then the second relevant clause for your lordship's consideration, your lordship will find on page 51 under the heading governing law. This agreement shall be governed by and construed in accordance with Indian law without reference to its conflict of law principles, subject to the provisions of section 11 above. Licensee consents to the jurisdiction of any court
Just a second. Yes.
They're sitting the territory for all claims, suits, or actions arising under this agreement, including claims of payment due or under or in connection with the licensee's use or possession of software and SAP or SAP AG proprietary information, and for enforcement of any award by an arbitrator under section 11 above. The provisions of the subsection 12.6 shall survive the termination of the expiration of the agreement. The United Nations Convention on Contracts for the International Sale of Goods shall not apply to this agreement. Very briefly, the facts were that SAP, although it's very well known and very famous for its accounting and HR software all over the world, they were trying something completely new called SAP Hybris for the travel industry. So we were part of the travel industry, and they approached us saying, look, you're doing your own portal. Our model is 90% aligned with you. In 6 months or to 10 months, we'll complete the whole job and we'll complete the portal for you. And then we agreed to do that. And then there was a rampant failure. So there's another GTC, which you'll find on page 181, which is the arbitration clause. And I accept that SAP AG was not a part of this arbitration agreement, had not signed the GTC, but the arbitration clause which we moved under was under page 181. Then, so the entire arrangement broke out. And if your lordships go straight away to page 399, as this is what happened. This is now from SAP AG Germany. They write to us, dear Vinay, thank you for raising your concerns to me. I'm disappointed that the project crisis continues and that you're not getting adequate follow-through.
Page 99.
Page 399.
399.
Just 1 second. Are there anywhere?
99 is not.
Thank you for raising your concerns to me. I'm disappointed to hear that.
Mr. Advani, just 1 second.
Anybody who is not still.
399. 399 is that Annexure P10.
Correct.
Annexure P10, sir.
You got Annexure P10?
Sir, you have it, sir. May I go ahead?
Yes.
1 minute, 1 minute.
The page 399, Annexure P10. This is now an email from SAP.
Yes.
Yeah, this is an email from SAP AG now. SAP Germany gets involved now. Dear Vinayak, thank you for raising your concerns to me. I'm disappointed to hear that the project crisis continues and they're not going to get adequate follow-through. The SAP team, not just SAP India, is committed to getting an outcome for you and achieving success with the project. With this viewpoint, we will take the following immediate actions. Assign an escalation manager on site, Suresh Srinivasan, who's from SAP Singapore, to drive transparency on the core issues and expose the root cause of failure points. Suresh is on site now and will continue. The war room is fully satisfied with the right expertise. We will also arrange for global experts to assist the team on the ground. And I've asked the team to ensure that I'm getting regular status reports on the progress. Re-instance strong governance produces regarding steering committee meetings. Mark Hetler is on point and will be your executive sponsor. Mark will be in India next week. Deliver credible plan for solution delivery and audit requirement to ensure all components are part of the solution delivery plan. I have asked Mark Hetler to take executive ownership of delivery of the project, supporting the team on ground in any way they can. Note that Mark reports to Michael Verhoeven, who is the newly hired SVP for SAP's Digital Business Services division in APJ, and he will also be glad to support you moving forward. Rest assured that SAP will be open and transparent on the project. It is moving from you from a position of trust to a position of certainty. Meanwhile, I will monitor the progress of your project and thank you for reaching out to me. And best regards, Michael Klein-Meller. There's a series of correspondence after that. I can take your lordship to all of them. But basically, SAP Germany then takes control of the project entirely and says, we will deliver the project. Then the project fails. And what happens is the contract is termed, there's all a large number of correspondence from SAP Germany taking total control and saying, we are responsible for delivery, we will do the best we can. Whatever happens, the project does fail, and SAP India starts the arbitration against us. Arbitral tribunal is appointed, and we make a Section 16 application before the arbitral tribunal that, look, you can't do the arbitration only under the GTC. There are 4 agreements involved. So this arbitration should be dismissed, and SAP AG under the terms of chloro control should also be made a party, because apart from the license fee that we are paying, we're also claiming loss of profits, which is a large amount. So this arbitration was going on and the company went into bankruptcy. So after the bankruptcy, there was a moratorium and that arbitration ended. Then the resolution professional instructed us to start an arbitration, and we started the arbitration against SAP India and SAP Germany, both of them. And that was the Section 11 application that was before the court when it was considering whether or not then Justice Ramana judgment came saying that I have some doubts on this group of companies doctrine and it should go before a larger bench. And so with all due respect, if we can have a look at Justice Suryakant's judgment, although he was in a minority.
Let's see the referring judgment first, and then we will look at Justice Suryakant's judgment, because Justice Suryakant says there is no reason for evidence.
Sorry, what is it? Yes, sir. And he, sir, but the main thing is he goes through all the details.
It's 9:29. Right? Then
Justice Suryakant explained in some details of why he thinks that the group of company doctrine is valid. If you go, sir, to Justice Ramana's judgment, I'm not going to take your lordship through the facts of the case because I've explained to you what has happened already.
The facts are only to give us a little flavor of it all, that's all.
Yes, sir. So that SAP India started the arbitration and we went for Section 16 application saying that arbitration not maintainable. because you have to have an arbitration under all the 4 agreements, and SAP Germany is a necessary party to this entire thing, because SAP Germany had taken over the project totally itself. So, and that project anyway, because the bankruptcy, that arbitration stopped.
So let's look at now the referral order, and we can look at the referral order. If you have all of you the PDF pages, the referral order is at PDF page 863.
860
If we go straight away to Sir Justice Ramana's judgment,
Yes.
from paragraph 16 onwards.
15 is enough.
Page para 15 onwards.
Para 15 onwards. Arbitration is the creature of contract, which has been provided statutory backing under the Arbitration Act to usher in party autonomy.
1 second. Just 1 second. 1 second. Got it?
So may we ask paragraph 15, sir?
Yes. Jamshid, you got it?
Yes.
The arbitration is the creature of contract, which has been provided statutory backing under the Arbitration Act to usher in party autonomy, quick disposable, and an efficacious remedy or alternative remedy. Arbitration has been a great boon for Indian jurisprudence, wherein numerous cases have been methodically dealt with us in an effective manner without taking the meandering course of litigation before courts. One of the most challenging areas of arbitration practice, both theoretical and practical, relates to multi-party and multi-claim proceedings. Usually, arbitration involves parties who explicitly entered into the arbitration agreement or parties with successor interests and claiming under them in some cases. It happens that third parties are bound by an arbitration clause by tacit consent, etc. Doctrine of group companies is one such area which is utilized to bind third parties to an arbitration agreement. Theoretically, the policy of consideration of efficiency is argued to allow such joinders. However, until a legal basis of the same is provided, efficiency cannot itself be the sole ground to bind a party to an arbitration. May I just say, Your Lordship, please, is that we have the argument really in substance is not that this is only for the sake of efficiency. The real substance of the argument is there has been a tacit consent to the arbitration agreement itself. There's an implied consent or a tacit consent to the arbitration agreement based on the facts. Just like in our facts I showed you, SAP Germany came and took over the whole project and say we are running it. And therefore we say SAP Germany or parties that actually not only with implied consent or tacit consent or by conduct actually are running the project, that's how they are brought into the arbitration. And the substance of that is also based on the New York Convention and our Section 7 of the Arbitration Act, which I will come to. The Section 7 of the Arbitration Act defines an arbitration agreement. This is paragraph 18. Section 7 of the Arbitration Act defines an arbitration agreement being a creature of contract. The realm of arbitration is one of consent. The bare reading of the aforesaid provision indicates that the parties must reduce the intention to submit their existing or future disputes to arbitration in writing. The statute does not mandate a particular form of an arbitration agreement. The intention of the parties can be inferred from the exchange of letters, telex, telegrams, and even electronic means. The existence of the arbitration agreement can be deduced once it's ascertained that the parties were ad idem, either through a contract, conduct or correspondence, see so and so. Therefore, the question of the extension of the arbitration agreement to non-signatory necessarily also involves the question of extension of the scope and effects of the jurisdiction of the arbitral tribunal over such companies. Would your lordship just see section 7 for one moment, Milord? Section 7 of the Arbitration Act.
Yes.
Your lordship, let us see section 7(1). In this part, the arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined relationship, whether contractual or not. They use a very wide expression, defined legal relationship, whether contractual or not. So there's a clear implied term there that if the parties are involved in the contract, and whether they are signatories to the contract or not will be secondary, because they say whether contractual or not in our section 7. So then going back to the judgment again, if we go back to paragraph 19, the doctrine can be clearly stated to have originated in Dow Chemical France versus Isover versus Saint-Gobain. In Dow Chemical, it was the subsidiaries of Dow Chemicals which initiated the arbitration proceedings against Isover. In that case, Isover objected to the basis on which the subsidiaries of Dow Chemicals chose to arbitrate without some of them having entered into valid arbitration agreement with Isover. The tribunal, while disregarding the contention of Isover, held that Dow Chemical groups operated as a single economic reality, and thus non-signatories were also bound by the arbitration agreement. We may note that the Dow Chemicals case relied to a situation where a non-signatory did not resist arbitration. Thereafter, they wished to join an arbitration already initiated by its affiliates. The effect of this position has not been evaluated in any precedents of this court and needs to be examined. With all due respect, all chloro control, etc., are all based on the Dow Chemicals. They've all examined this, and they've examined this at some length, and then come to the conclusion of implied consent. The first case which we dealt with is group of company doctrine during domestic arbitration. So, Sukanya, since Section 8 has been now amended, I shall lordship, I will not trouble with Sukanya judgment, because now chloro control has overtaken it, and so is the amendment to Section 8. If your lordship goes straight away to paragraph 21, the next important case which dealt with the group of companies doctrine was chloro control's case. The court at the outset acknowledged that there were various schools of thought when it came to the doctrine and arbitration jurisprudence. It was this content that the court had to formulate an opinion to provide a best fit for the doctrine of Indian jurisdiction under Part 2 of the Arbitration Act. As many foreign parties involved, the court had to invoke Section 45 of the Arbitration Act and for appointment of an arbitrator. Section 45 of the Arbitration Act stood as under 45. Power of judicial authorities to refer parties to arbitration. Notwithstanding anything contained in Part 1 of the Civil Procedure Code, 1908, a judicial authority, when seized of an action in a matter in respect to which parties have made an agreement referred to in Section 44, shall, at the request of one of the parties or any person claiming through or under him, refer the parties to arbitration unless it finds that the said agreement is null and void, inoperative, or incapable of being performed. The court compared Section 45 of the Arbitration Act to Article 2 of the Judicial Model Law and formulated the following ingredients for a judicial authority to examine at a referral stage. Does the arbitration agreement fall under the scope of the convention? Is the arbitration agreement evidenced in writing? Does the arbitration agreement exist, and is it substantially valid? Is there a dispute? Does it arise out of a defined legal relationship, whether contractual or not? And do the parties intend to have this particular dispute settled by arbitration? Is the arbitration agreement binding on one of the parties to the dispute that is before the court? Is this dispute, not one of the parties, or on the parties, both the parties, is this dispute arbitrable? The court noticed distinction in the language under Section 45 and Section 8 of the Arbitration Act in the following manner. Product control so and so. We have already noticed that the language of Section 45 is at a substantial variance to the language of Section 8 in this regard. In Section 45, the expression any person clearly refers to the legislative intent of enlarging the scope of the words beyond the parties who are signatories to the arbitration agreement. Of course, such applicant should claim through or under the signatory. Once this link is established, then the court shall refer them to arbitration. The use of the word shall would have been given its proper meaning and cannot be equated to the word may as liberally understood in common parlance. The expression shall in the language of 45 is intended to require that the court would necessarily make a reference to arbitration if the conditions of the provision are satisfied. To that extent, we find merit in the submission that there is a greater obligation upon the judicial authority to make such a reference than it is in comparison to the 1940 Act. However, the right to reference cannot be construed to be strictly indefensible right. One can claim the reference only upon satisfaction of the prerequisites in sections 44 and 45, read with the Schedule 1 of the 1966 Act. Thus, is it a legal right which has its own contours and is not an absolute right free of any obligation stroke limitation. Normally, arbitration takes between parties who have from the outset between the parties to the arbitration agreement, as well as substantive contract underlining the agreement. But it does occasionally happen that the claim is made against or by someone who is not originally named as the party. These may create some difficult situations, but certainly they're not absolute obstructions to law, the arbitration agreement. Arbitration thus could possibly be between a signatory to an arbitration agreement and a third party. Of course, heavy onus lies on that party to show that in fact and in law, it is claiming through or under the signatory party as contemplated under Section 45 of the Act. Just to deal with such situations illustratively, reference can be made to the following examples in law and practice of commercial arbitration in England. By Sir Michael Muscle, the claimant was in reality always a party to the contract, though not named in it. The claimant has succeeded by operation of law to the rights of the named party. The claimant has become a party to the contract in substitution for the third party, for the named party, by virtue of a statutory or consensual novation. The original party has assigned to the claimant either the underlying contract together with the agreement to arbitrate, which incorporates or the benefit of a claim which has already come to existence. Now, Lordship, just turn back for a moment to item 1 of this on the previous page. The claimant was always in reality always a party to the contract, though not named in it. That, in my view, may not is the substance of the whole group of companies doctrine. And the party was always an implied consent to the contract to start with in the performance, in the termination, and right through the contract. So if that item number 1 is met, the other tests may not be applied. Simply if you fall under item 1, that you were always intended to be a party to the contract, like in our case, SAP took over the contract and ran the contract. Totally. These are other 3 methodologies are a little bit separate from the first one. The first one is the dominant feature. From the above, it is clear that the court was of the firm opinion that there must be a legal relationship between the non-signatory party to the arbitration agreement.
One second.
But
in a contract like this, where the party based in Germany had actually taken over, what prevented the parties then to have also entered into an agreement? Because now you're relying that claimant was in reality always a party to the contract, although not named in it. Why should such confusion remain, and then we have to go into the doctrine of to sort of invoke arbitration.
So I agree. So in an ideal situation, a separate contract should have entered into. But we are not in an ideal situation. We're in a situation where both parties recognize clearly that SAP Germany will come and support the contract. And they factually came, they brought their people and actually tried to perform the contract. So I agree, in an ideal situation, there could have been another contract. I'm not suggesting otherwise. But we are coming to a situation where they obviously impliedly consented to the entire agreement. Otherwise, how would they participate in it? They did not participate gratuitously, they were paid for it.
All right, let's go ahead and see what else. You are in para 24, is it?
I finished 24, so para 25.
25, all right.
24, I just said, so point number 1 is the most important one of the implied consent.
All right.
Para 25. While expanding on the legal relationship, the court in Cloro Control's case accepted the group of companies doctrine as sufficient basis to establish this legal relationship. However, while expounding on the ingredients of the doctrine itself, the court brought the intention of the party as to whether they were ad idem to treat a non-signatory as being party to the arbitration agreement. This postulation conflates a contractual understanding of the group of companies doctrine, which is all within the framework of arbitration without alluding to the contractual principles. So I'll just, again, once I pause here for a moment, say they do allude to the contractual principles because they say there's an implied consent. It's not that they do not ignore the contractual principle. They say they only became party because of an implied consent.
All right.
On the one hand, this court reduced the threshold of arbitration being a consensual affair. On the other hand, the doctrine of group companies is transport on requirements under contract law to bind a party to an arbitration. An attempt was made by the court to find a basis for the reading of the group of company doctrine within the language of Section 45 of the Arbitration Act in the following manner. Having examined both the above stated views, we are of the considered opinion that it will be on the facts of a given case that would act as a precept to the jurisdictional forum as to whether any stated principle should be adopted or not. If in the facts of a given case it is not possible to construe the person approaching the forum as a party to the arbitration agreement or a person claiming through or under such a party, then the case would not fall within the ambit and the scope of the provisions of the section, and it may not be possible for the court to permit reference to arbitration at the behest of or against such a party. We have already referred to judgments of various courts that state that arbitration should be possible between signatories to an agreement and a third party. Of course, heavy onus lies on the party to show that in fact and in law, it is claiming that under or through a signatory basis or contemplated under Section 45 of the 1966 Act. And 28, it is interesting to note that the court discussed some judgments from the United Kingdom in this regard. In Judicial v. so-and-so, the court interpreted the term claiming through or under while staying a case against a company that was neither a party nor privy to an arbitration agreement. Here, the non-signatory was a fully owned subsidiary. And its parent company was a signatory to the arbitration agreement. The subsidiary had claimed that it had a right to sell patented articles which it had obtained from the parent company because the parent company had ordered the sale of the patented articles. A stay on the litigation was granted, but the court concluded that the subsidiary was claiming through or under the parent company. This meant that if the parent company was entitled to, under the license agreement, to sell the articles, and the same right flowed to the subsidiary company as well. Although this case did not explicitly indicate the acceptance of the group of company doctrine under the English law, the wordings can only be said to have left door open to the possibility of such inclusion. In any case, the court in the City of London versus Sancheti overruled the Swift case. So I'll just pause here for a moment. I can take you to that judgment if you want. The facts are so different in that case, number one. And they considered both possibly. They said, if it is overruled, this is the result. Even if it is not overruled, the same result follows on the facts of that case. They also go to theory that if the contract is not overruled, then also the same result will follow. So they did consider both possibilities. In any case, the Court of Appeal versus City of London versus Sancheti overruled the Euclid case. It does not do so in terms of it, only it considers both possibilities. the court pronounced was a mere legal or commercial connection is insufficient. In essence, the restricted phrase claiming through or under to only those third parties who assert their right on the basis of rights of a signatory to an arbitration agreement. They noticed that this court in product control, while observing both cases as persuasive, however, does not provide reasoning in favor of one interpretation or the other in the following manner. I'm happy to take you to chloro control where the reasoning is provided in terms, where they say that it is because of an implied consent. They say so in terms, not just because of claiming through, but it's because of an implied consent. In Russell versus Searle, the court held, the argument does not admit of such elaboration. But I see no reason why these words in the Act should be construed so narrowly as to exclude a wholly owned subsidiary company claiming as here a right to sell patented articles which it has obtained from and has been ordered to sell by its parent. Of course, the arbitration proceedings so decide, it may eventually turn out that the parent company is at fault and not entitled to sell the articles in question at all. And if so, the subsidiary company will be equally at fault. But if the parent is blameless, it seems only common sense that the subsidiary should be equally blameless. The two parties and their actions to, in my judgment, so closely related on the facts in this case that we right to hold that the subsidiary can establish that it is within the purview of the arbitration clause on the basis that it is claiming through or under. The parent to do so would in fact be doing what ultimately held to be wrongful or not. However, the view expressed by the Court of Russell does not find approval of the Court of Appeal and City of London versus so-and-so. In para 34, it held that the view in Russell need not be followed and stay could not be obtained against a party to an arbitration agreement or a person claiming through under such an agreement as mere local or commercial connection is not sufficient. But the Court of Appeal hastened to add that in cases such as one of Mr. Sanchit, the Corporation of London was not a party to the arbitration agreement. So this was a bilateral investment treaty involving the City of London. So there were a whole lot of other issues involved there. But the relevant party in the United Kingdom government, the fact that in certain circumstances the state may be responsible under international law on the acts of one of its local authorities or may not have to take legal steps to address wrongs committed by one of the local authorities does not make the local authority a party to the arbitration agreement. Now, the facts here are so different that they are not comparable to chloro control. This court ultimately concluded that Sukanya holdings were not applicable for interpreting Section 45 of the Arbitration Act. The ratio of Sukanya holdings was restricted to the arbitration on the Part 1 of the Arbitration Act as such. It may be noted that following the ratio of chloro control, the 246 Law Commission report recommends amendment to Section 21H and 8 of the Arbitration Act to modify the definition of party under Part 1 of the Arbitration Act to a party to an arbitration agreement or any person claiming or through under any such party to cure the anomaly pointed out by this court in chloro control's case. The relevant observations, the 246 Law Commission report are stated below. It will thus be incongruous and incompatible with the consensual and agreement-based status of arbitration as a method of dispute resolution to hold persons who are not parties to the arbitration agreement to be bound by the same. However, then paragraph 62, however, a party does not necessarily mean only the signatory to the arbitration agreement. In appropriate context, a party means not just a signatory, but also persons claiming through or under such signatory, for instance, successor of interest, such parties, alter ego of such parties. This is particularly true in the case of unincorporated entities where issues of personality is usually a difficult legal question and raises a host of other issues. This principle is recognized by the New York Convention 1985, in which Article 2.1 recognizes an agreement between the parties in respect of a defined legal relationship, whether contractual or not. The same words used in our Section 7, sir, whether contractual or not, in our Section 7. The Arbitration and Conciliation Act under Section 7 borrows the definition of the arbitration agreement from the corresponding position at Article 7 of Judicial Model Law, which in turn borrows Article 2 from the New York Convention. However, the definition of the words party in Section 2.1H refers to a party to mean a party to an arbitration agreement. This cannot be read restrictively to imply a mere signatory to an arbitration agreement. Since there are many situations and contexts where even a non-signatory can be said to be a party to an arbitration agreement. This was recognized by the Honorable Supreme Court in Court of Control, where the Honorable Supreme Court was dealing with the scope and interpretation of Section 45 of the Act, and in that context discussed the scope of the relevant doctrines and the basis of non-signatories which could be bound by the arbitration agreement, including in cases of interrelated contracts, group of companies, doctrine, etc. The interpretation given by the Honorable Supreme Court follows from the wording of Section 45 of the Act, which recognizes the right of a person claiming through or under a party to apply to the judicial authority to arbitration. The same language is found in Section 54 of the Act. This language is, however, absent in the corresponding provisions of Section 8 of the Act. It is similarly absent in other relevant provisions where the context would demand that a party also include the party claiming through or under such a party. To cure the anomaly, the Commission passed an amendment for the definition of the party under Section 21H of the Act. So I appreciate that Section 8 was amended and Section 21H was not amended. But if you look at the questions raised by Justice Ramana, that is not the issue he raises. He does not say that the fact that another party can be made party in arbitration because 21H was not amended. That is not the question raised in the judgment. Because the Law Commission itself said the party cannot be interpreted narrowly. It must include parties who are very closely related to the contract. And although Justice Ramana points out that 21H party definition is not changed, that is not the issue he raises finally for the court's consideration. I'll come to that as we go along, but I'm just pointing that out at this stage. We must here also state that the Law Commission did not examine an interpretation of claiming through or under. Rather, it simply recognized that there may be a need to extend the same to arbitration under Part 1 of the Arbitration Act. With all due respect, if you see paragraph 62, that is not what the Law Commission says. The Law Commission says, in many circumstances, the party will include parties involved in the contract, and more or less saying it does not require amendment. That is what the Law Commission feels. It feels that in many circumstances, the party does not have to be recommended as to be defined narrowly. In pursuant to the amendment recommended, the legislature amended the, I'll not take you to the column, but Section 8 was amended and Section 2 was not amended. If we go then to paragraph 34, the 215 amendment brought in 4 amendments to Section 8.1. Firstly, the scope of the concept of the party has been expanded, including a person claiming through or under. Secondly, the amendment also clarified the scope of judicial interference, and the same is to be limited only to prima facie examination regarding the existence of the arbitration agreement. Thirdly, the cutoff for submitting an application under Section 8 of the Arbitration Act has been stated to be the date of submitting the first statement of the substance of the dispute. Fourthly, the aforesaid amendment shall apply notwithstanding the prior judicial precedent. However, it may be observed that the Parliament has not carried out any amendment to Section 21H of the Arbitration Act. The impact of the absence of such amendment needs to be clearly examined by this court. This has created anomalous situations wherein potentially a party claiming through or under could be referred to an arbitration or would not have the right to seek relief under Section 9 of the Arbitration Act. This is merely an illustrative example to indicate a potential anomalous situation. The Lordship will see in the question he framed, this is not the question framed in this judgment at the end. In Amit versus Lalchand Shah versus Rishabh Enterprises, this court had to deal with a case wherein 4 parties had executed 4 agreements for the single purpose of commissioning a photovoltaic solar plant in Uttar Pradesh. A division bench of the court treated the contracts as interconnected. Although the parties were different, yet the agreements were effectuated in light of a single commercial project. Therefore, the court applied the amended Section 8.1 of the Arbitration Act and extended the arbitration to non-signatories and opined that the dispute could be resolved only by referring all the 4 agreements to the parties therein to the arbitration. The court observed then by section paragraph The parties to the agreement, namely Rishabh and Jui India, equipment and material supply agreements, engineering, installation, and commissioning contract, and the parties to sale purchase agreement between Rishabh and Aston Field are one and the same as that of the parties in the main agreement, namely equipment lease agreement. All the four agreements are interconnected. This is a case where several parties are involved in a single commercial project, solar power at Dongri, executed through several agreements, contracts. In such a case, all parties are to be covered by the arbitration clause in the main agreement, equipment lease agreement. Since all the agreements of Rishabh with Jui India, Aston Field, and the purpose of commissioning the photovoltaic cell plant at Dongri Raksas district, Jhansi, Uttar Pradesh, the High Court was not right in saying that the sale and purchase agreement is the main agreement. The High Court, in our view, erred in not keeping in view the various clauses in all the three agreements, which make them an integral part of the principal agreement, namely equipment, lease agreement, and the impugned order of the High Court cannot be sustained. The interpretation, 36, the interpretation of chloro control was further expanded by the three-judge bench decision in the court in Cheran Properties, the Kasuri Limited. In that case, the court interpreted Section 35 of the Arbitration Act to enforce an award against a non-signatory, even though it did not pass with it. So if your lordships will have a quick look at Section 35 for a moment, it's a very short section. My lords have Section 35?
Yes.
Eligibility of arbitral awards. Subject to this part, an arbitral award
35
Finality.
shall be final and binding on the parties and persons claiming under them respectively.
Right.
So that Cheran judgment expanded this based on Section 5 and even permitted enforcement of an award against a party who was not even a party to the arbitration. For the purpose of enforcement, they permitted against a third party on the basis of claiming through, even though that party was not a party to the arbitration itself. Then this court in Reckitt, wherein the two-judge bench of this court refused to apply the group of companies doctrine, and the applicant failed to prove the commonality of intention of the respondents to be bound by the arbitration agreement. Keeping in mind and chloro controls, in other words, whether the indisputable circumstances go to show that the mutual intention of parties was to bind both the signatory as well as the non-signatory party, namely the respondent 1 and respondent 2 respectively, where the existence of an arbitration agreement between the applicant and the said respondent. Thus, respondent number 2 was neither a signatory to the arbitration agreement, nor did it have any causal connection to the process of negotiations preceding the agreement. So there are findings of fact that the second party was not involved in the contract itself at all. So you can't simply join it on the basis of group of company document because the companies are related or something. They must be involved in the actual performance of the contract. So here the finding of fact was the agreement nor did have any causal connection with the process of negotiation preceding the agreement or the execution whatsoever. The main plank of the applicant that Mr. Frederick Renders was acting for and on behalf of respondent number 2 and had the authority of respondent number 2 collapses, then it must necessarily follow that respondent number 2 was not a party to the said agreement, nor had given assent to the arbitration agreement. In the absence thereof, even if respondent number 2 happens to be a constituent of the group of companies, which respondent number 1 is also a constituent, that will be of no avail. So they say very clearly that just you can't blindly apply the group of companies document. The parties must have a natural connection with the contract. They must be involved in the performance of the contract or negotiation of the contract or in some manner involved. Not simply that they're part of the same group. I won't trouble you with the rest of that paragraph because that's a finding of the court then that on finding the fact. And if you go to the next paragraph, my lord, go to para 35. In the division bench of the court in Mahanagar telephone number, Telegram Nigam was a Canara Bank, it is observed that the group of company document can be utilized to bind a third party to an arbitration if a tight group corporate structure constitutes a single economic reality existed. The court held as under the circumstances in which a group of companies doctrine could be invoked bind the non-signatory affiliate of a parent company or inclusion of a third party to an arbitration. If there's a direct relationship between the party which is a signatory to the arbitration agreement, direct commonality of the subject matter, the composite nature of the transaction between the parties, a composite transaction refers to the transaction which is interlinked in nature or where the performance of the agreement may or may not be feasible without the aid, execution, the performance of the supplementary or ancillary agreement for achieving the common object and collectively having a bearing on the dispute. The group of company document has also been invoked in cases where there's a tight group structure with strong organization and financial links so as to constitute a single economic unit or a single economic reality. In such a situation, signatory and non-signatories have been bound together under the arbitration agreement. This will apply in particular when the funds of one company are used financially to support or restructure other members. So, sir, what they're saying is that not merely because you're part of the same group, you must be involved in a transaction in some particular way, then apply the group of company document, not just blindly because the companies are associated with each other in some manner or the other. You may notice that these cases have been decided by the court without referring to the ambit of the phrase claiming through or under occurring under Section 8 of the Arbitration Act. That is based on the
Yes, Mr. Advan.
Yes.
yes, sir. Then, sir, all I'm saying is that the group company document is a wide phrase, but it includes the fact that there must be an involvement in the contract, not just simply that you are part of the same group. It has to go wider and say there's an implied consent to the contract and to the arbitration agreement.
Justice Suryakant really refers to that when Justice Suryakant cites various judgments. He says it's not enough that you are really part of the same group or economic reality, but there has to be something more, either participation in the process of entering into the contract, or the performance, or the termination of the contract.
So therefore, sir, what we were going to suggest that when you are considering a Section 11 application, you take a prima facie view, and the parties have a right to file a Section 16 application for the arbitrators to go into the details whether all the companies are involved or not involved, should they be a party, should they not be a party. So long as this court is satisfied prima facie there was an involvement of the non-signatory, then your lordship will leave it to the arbitral tribunal under 16 to decide. And so anyway, reading the judgment, going to paragraph 36, the ratio of chloro control alludes to the subjective intention of the parties to be bound by the arbitration agreement, where the parties have clearly not been signatory to the agreement. Reconciling the two is difficult and requires exposition in this court. So the Law Commission itself felt that way when they said, although the word party, even that word party should be read broadly to include all parties participating in the contract or involved in the contract and should not be restricted only to the signatory of the agreement. That is why Section 2 ultimately did not get amended.
In fact, Justice Ramana's judgment does not refer to the decision in ONGC, though Justice Suryakant takes note of the ONGC judgment.
Yes, I appreciate that. So I was going to come to that. But he takes note of the decision of ONGC and also the Cheran decision where there was an enforcement of the arbitration award against a non-signatory who was not participating in the arbitration itself. That has been expanded very broadly, sir, after that.
Yes, Mr. Advan.
Paragraph 37, it may be noted that the doctrine as expounded requires joining of non-signatories as parties in their own right. This joinder is not premised on non-signatories claiming through or claiming under. Such a joinder has the effect of obliterating the commercial reality and the benefits of keeping subsidiary companies distinct. Concepts like single economic entity and economic concepts are difficult to be enforced as principles of law. So here, Justice Ramana says two different things. So he seems to indicate that if they are involved in the whole transaction, then it can make sense. But otherwise, they have separate judicial entities, and therefore they should not be mixed up because that's the whole concept of having a separate judicial entity. The areas which are left open by court and court of control case has been created certain broad-based understanding of the doctrine, which may not be suitable and would clearly go against distinct legal entities of companies and party autonomy itself. The Fawcett exposition above case clearly indicates an understanding of the doctrine which cannot be sustainable in a jurisdiction which respects party autonomy. There's a clear need for having a relook at the doctrine and ingredients concerning the group of companies doctrine. So therefore, what Justice Ramana is suggesting that possibly this omnibus word group of companies may not be enough. There may be more explanation required. Were they impliedly consenting to the arbitration agreement or impliedly party to the arbitration itself? Just because they were a group of companies would not be sufficient. Internationally, the group of companies doctrine has been accepted in varying degrees in Swiss courts. Usually do not recognize such a doctrine under Switzerland law. Our English court has observed as under. It's often suggested beguilingly that it would be technical for us to distinguish between the parent and subsidiary company in this context. Economically, he said they were one, but we're not concerned with the economics, but with the law. The distinction between the two is in law fundamental and cannot therefore be bridged. Similarly, in the case of Peterson's farm, an arbitral award was challenged when the claimant received damages on his behalf, as well as his group count entities before the Queen's Bench division. The court partly set aside the award and stated the group of company document does not form part of English law. It further stated that the corporate structure exists in separate legal entities and a general agency relationship would defeat this purpose. The court held that in commercial terms, the creation of a corporate entity, a corporate structure is by definition designed to create separate legal entities for entirely legitimate purposes, which will often, if not mutually, be defeated by general agency relationship. So we'll come to that judgment. The facts are entirely different there, sir. The High Court, Australia, in Canning Research Laboratories, interpreted the phrase claiming through and under in the following manner. A person who claims through or under a party may be either a person seeking to enforce or a person seeking to resist the enforcement of an alleged contractual right. The subject of the claim may be either a cause of action or a ground of defense. Next, the proposition through and under convey the notion of a derivative cause of action or a ground of defense. That is to say, the cause of action or ground of defense derived from the party. In other words, an essential element of the cause of action or defense must be or must have been vested in exercisable by the party before the person claiming through or under the party can rely on the cause of action or ground of defense. So just again to put in perspective facts of my case, supposing the software that we were dealing with, hybrid software that was supplied by SAP India, failed. Can they say this is not our fault, it was the parent company fault? Because we had got a license from them from the software. So we have no responsibility, the parent company has the responsibility. So your lordship will consider the group of company doctrine also in that context where there's a sub-license given out. A sub-license is given out, the party uses the sub-license and that sub-license fails. Can the parent company which owns the original license escape responsibility? In our case, factually, they came and said, no, we will fix the whole thing. And also that is, our case is much stronger. But there will be many cases of this sort where a parent company licenses the software and that or a patents a product and that patent or the license fails in the future. In the aforesaid case, a company and its creditors had entered into contract through having an arbitration clause. Subsequently, the litigation ensued and a question arose as to whether the liquidator of the company could rely on the arbitration clause. The court held that the liquidator must be a person who can claim through or under the company because the ground of defense and the cause of action he depends are vested on the company or are exercisable company. This meant that an essential element of cause of action or defense must be or have been vested or exercisable by the original party before the person claiming through or under the said party can rely upon. Your Lordship may say that in our view, this is a very narrow view taken. It's not that just because a liquidator came in the state of position. What if the licenses are owned by a parent company and then operated by a subsidiary in India or some other country, and that software completely fails or the patent is breached? Then the question of claiming through will definitely come through to it. Not just because the liquidator stood in the footsteps of the company. Viewed from a different angle, this court in Vidya Dole versus Durga Trading noted that the ambit of judicial interference under Section 8 and Section 11 are similar. Relevant observation in the court in the aforesaid case in relation to the power under Section 8 and Section 11 is as follows. Moreover, the amendment to Section 8 now rectifies the shortcomings pointed out in chloro control. And go and say, and with respect to the domestic arbitration jurisdiction issues concerning whether certain parties are bound by a particular arbitration under a group company doctrine or a good faith, etc., in a multi-party arbitration, is a complicated factual question which are best left for the tribunal to handle. The amendment to Section 8 on this front also indicates a legislative intention to further reduce the judicial interference at the stage of reference. So the learned judge then says, please apply the same principles of Section 8 and Section 11 and leave these issues to the tribunal to consider. So the court should only prima facie file a point of view that in my case, if SAP Germany comes and takes over the whole project and says, no, we will sort it out and we will do it. Whether SAP Germany should be a party or not, prima facie appears to be there, and let the tribunal sort it out under Section 16 if they want. Courts, while analyzing a case under Section 8, may choose to identify the issues which require adjudication pertaining to the validity of the arbitration agreement. The court cannot rule on the invalidity of the arbitration agreement on a prima facie basis. Then the court should stop any further analysis and simply refer all the issues to the arbitration to be settled. And the learned judge said, Section 11, the principles should be the same. We are cognizant of the fact that the statutory language of Section 8 and 11 are different. However, materially, they do not vary, and both sections provide for limited judicial interference at reference stage as enunciated above. Sections 8 and 11 of the Act have same ambit with respect to judicial interference. The courts under Sections 8 and 11 has to refer a matter to the arbitration or to appoint an arbitrator as the case may be, unless a party has established prima facie summary findings, a case of non-existence of a valid arbitration agreement, by summarily portraying a strong case that is entitled to such a finding. In the aforesaid case of Vidya Jolia, the court primarily delineated the threshold standard of reference to arbitration. The aforesaid case predominantly laid down when an application is made under Section 11 of the Arbitration Act, considering the scope of judicial intervention, the courts are only required to look into the prima facie existence of an arbitration. And with all due respect, we suspect that is in our case, where we have shown facts that SAP Germany came over and took over the contract totally. Then your lordship will leave the rest to the arbitral tribunal to decide whether they are appropriate party or not. The aforesaid case predominantly dealt with the scope of judicial interference at the referral stage. However, this court did not have occasion to explore the jurisprudential possession of the group of company documents required ingredients to refer a non-signatory to arbitration, especially the scope of judicial reference at the stage of Section 8 and 11 of the arbitration needs to be relooked, considering the ambit of unamended Section 2(1) of the Arbitration Act. Your lordship will see that what the the Law Commission recommended, that the party should not be defined narrowly before recommending when they say it cannot be defined narrowly and will depend on the facts of each case. If there are non-signatories involved in the contract, in any case they're involved, so they can be parties to it. So whether the definition of party itself was changed or not should not make any difference to the group of company doctrine, which is based on implied consent to the arbitration agreement. An arbitration agreement may be binding on parties, whether signatories or non-signatories, provided there is sufficient legal basis to bind them. Most legal basis for binding non-signatories to the arbitration agreement are of a contractual origin, like agency etc., jurisprudence has shown that arbitration being a creature of contract does not very well did not sit very well in binding non-signatories. Expounding on the same, Professor William Park, in one of his key works, captured the dilemma while attaching a non-signatory to the arbitral process as under. For arbitration motions, to join non-signatories to create a tension between the two principles, maintaining arbitrators' consensual nature and maximizing an award's practical effectiveness by binding related persons. Pushed to the limit of the logic, each goal points in an opposite direction. Resolving the tension usually implicates the two doctrines discussed below: implied consent and disregard of corporate personality. The term non-signatory remains useful for what may be called less than obvious parties to an arbitration clause, individuals and entities that never put pen to paper, but still should be part of the arbitration unless the circumstances of the relevant under the circumstances of the relevant business relationship. The label does little harm if invoked merely for ease of expression to designate someone whose right or obligation to arbitrate may be real but not self-evident. More significantly, the fact that a non-signatory might be bound to arbitrate does not dispense with the need for an arbitration agreement. Rather, it only means that the arbitration agreement takes its binding force to some circumstances other than the formality of signature. It is evident from the discussion above that the group of company doctrine must be applied with caution, and mere fact that a non-signatory is a member of the group of affiliated companies will not be sufficient to claim extension of the arbitration agreement to the non-signatory. In this context, Gary Bond notes as under group of company doctrine. Another significant but controversial basis for binding non-signatories to an arbitration agreement is the group of company doctrine. Under this principle, non-signatories of a contract may be deemed parties to associate the arbitration clause based on factors which are often roughly comparable to the relevant and alter ego analysis. In particular, where a company is a part of a corporate group is subject to the control or control of a corporation affiliate that has constituted a contract and is involved in the negotiation or the performance of that contract. Then that company may, in some circumstances, invoke or be subject to an arbitration clause contained in the contract, notwithstanding the fact That City of London judgment. Without.
Yes, yes, Mr.
Yes. I will.
Sorry for the diversion. Yes.
No, I appreciate it. I'm halfway through paragraph 46. When it says, unlike other bases for binding a non-stipulated arbitration agreement, such as agency, alter ego, estoppel, third-party beneficiary, or assignment, the group of company doctrine developed specifically in the arbitration context and is not typically invoked outside that context. At least thus far, the group of company doctrine has also been explicitly accepted in only a limited number of jurisdictions, in particular discussed below France. In part of that reason, the doctrine has been given rise to substantial controversy. May I just stop here for a moment, my Lord? Although Justice Ramanan says it's only accepted in 2 countries, that appears to be factually incorrect. We have researched now that 20 countries using the unilateral model of laws have accepted the group of companies doctrine. Although he says, Gary Bond in a footnote says only 2 countries have done it. Now, with all due respect, that is entirely factually incorrect. He goes on to say Gary Bond also refers in footnotes 222 and 223 to the fact that only a small number of jurisdictions, France and India, appear to have applied the group of company doctrine in the context of international arbitration and to the prevalent criticism of a group of company doctrine. So I'm quite happy. I will, at the end of this, provide you with a note showing, in fact, 20 countries have accepted it. France is not a unilateral model. 19 with a unilateral model have accepted it. And France, I've got one judgment also from Canada, one of Belgium, both of which have accepted it. So this is factually incorrect, what he is quoting Gary Bond's footnotes.
Now, Mr. Advani,
Yes.
this acceptance by the other jurisdiction,
Yes,
is
sir.
it through a statutory enactment or just by operation in the understanding of the arbitration regime?
Extending the arbitration regime, they are purely UNC, they have their Arbitration Act is a pure copy of the UNC Trial Model Act.
Yes.
And they've extended the group of companies doctrine the same way that India has done, and not by interpretation of a particular section, by the same concept of implied acceptance of the agreement.
Right acceptance. Very well.
This question of two countries only is, I think, factually incorrect.
That's okay. Actually, it's incorrect.
Yeah. It's in fact, as far as we've seen so far, 19 countries plus France, that's 20 countries. And 47. In view of the aforesaid discussion, we feel it appropriate to refer the aspect of interpretation of claiming through or under as occurring in Appendix Section 8 of the Arbitration Act, where the doctrine of group of company doctrines to a larger bend to provide clarity on the aspect. The law laid out in Cloro Control, supra, in cases following, it appears to have been based more on economics and convenience rather than law. This may not be a correct approach. The bench doubts the correctness of the law laid down in Cloro Control and cases following it. So with all due respect, it seems that the courts, when they've applied this, have applied this based on the fact there's been an implied consent to the agreement because those parties have actually participated in the contract. Otherwise, some contracts which are multi-contract arbitration, you'll be running 10 and 12 arbitrations for the same cause of action. And it's probably in 10, 12 jurisdictions. This may not be a correct approach. The bench doubts the correctness of the law laid down in Cloro Control and supra and cases following it. On a different note, we are cognizant that the reference to a larger bench should not be made in a casual and cavalier manner, and we see that the question raised herein are fundamental to the arbitration practice in India and have a large-scale representative. It's fundamental to international arbitration also, not just to India, my lord, and not confined to India only. In this context, we deem it appropriate to refer the matter to a larger bench as a threshold laid down by Shah Faisal versus Union of India stands adequately satisfied. In view of the aforesaid discussion, we deem it appropriate to refer this matter to a larger bench to expound on the intricacies of the group of company doctrine and answer the following questions. Whether the phrase claiming through or under in sections 8 and 11 could be interpreted to include group of companies doctrine. So what the learned judge does not refer, he does not say that because section 2 is not amended. He does not go into that controversy that should it be the bench whether section 2, the definition of party not being offended, should be referred to a larger bench. He confines it to the amendments to section 8 and 11, the claiming through or under. And whether the group of company doctrine as expounded by Cloro Control, supra and subsequent judgments are valid in law. But with all due respect, all of the judgments talk about implied consent. They gave the whole basis of the law, the implied consent. If your lordship permits me, I'll take you to the Lordship Suryakant's judgment also. That frankly answers all these issues.
We'll have to look at Justice Suryakant's judgment. Yes.
May I take you to that, sir?
Yes.
I've had the advantage of going through a scholarly and self-speaking order prepared by the Honorable Chief Justice, doubting the correctness of the three-judge bench of the court in Cloro Control versus Sven Trust Water Purification, and formulating the question of the law to be determined by a larger bench. But at the outset, I concur the contours of the group company doctrine needs to be settled by a larger bench. My thoughts are oriented in favor of the doctrine as an integral part of Indian arbitral jurisdiction for the reasons assigned below. The questions which have fallen for consideration in this case are whether the parent company of a respondent company 1, namely respondent 2, should be joined in the arbitration petition, regardless of the fact that the petitioner had entered into a SAP software end-user license agreement and SAP's enterprises support schedule with only the subsidiary. Petitioner sought greenfield solutions for its e-commerce problems, for which respondent number 1 provided its hybrid solution system. Over time, disputes arose between the parties during this phase. The petitioner had requested respondent number 2 to mediate between the parties. However, the parties could not be resolved. So we never asked them to mediate. We told them this is not working. Then they said we'd form a different global team, will come and do the job here. So the mediation came much later towards settlement. But the initial reaction was, look, this whole hybrid system that you've given us is not working. The mediation is not quite accurate because that comes much subsequently. However, the disputes could not be resolved. Subsequently, the petitioner initiated arbitration proceedings and sought to bind respondent number 2 to the proceedings, even though the said respondent not a signatory to the arbitration agreement. On the issue of whether respondent number 2 may be roped into arbitration pending between the petitioner and respondent number 1, Honorable Chief Justice has noted that the basis under Indian law for joining non-signatories to arbitral agreement has been a group of companies doctrine. While discussing holdings in Flora Control and Cheran Properties versus Honorable Chief Justice felt it necessary to revisit certain aspects of the decision and determine whether the manner in which they have invoked the group of companies document within Indian jurisdiction is consistent and sound. Honorable Chief Justice has eruditely analyzed the sustainability of the group of company doctrine and inter alia pointed out the following. 1. The application of the group of company document in Flora Control relies on the intent of parties to include a non-signatory to the arbitral proceeding. However, the court in that decision failed to adhere to the contractual principle on the basis of which such intent is interpreted. Joinder of non-signatories is based on the notion of a single economic unit, ignores commercial reality and the importance of treating different parties within the same group of companies as separate legal entities. Following Flora Control, there has been an expansion of the group of company doctrine. A broad inspection of the doctrine is at odds with the principle of party autonomy. The line of the judgment by this court in beginning of Flora Control seemed to be premised more on convenience and economic efficiency in resolution disputes rather than a consistent and clear legal doctrine which respects party autonomy and intent. The phrase claiming through or under, as prescribed in Section 8 of the Arbitration Act, as amended by the Arbitration Amendment Act 2016, may not be a legitimate basis for leading group of companies doctrine into Indian law, origin of the group of companies. So we have repeatedly said that it's not the issue of claiming under, it's the fact that they have agreed, implicitly agreed to the agreement, that is the doctrine. Not just the words claiming under, but because they've implicitly agreed and participated in the contract. The group of company doctrines has generally been invoked by courts and tribunals and arbitrations to either extend the arbitration agreement or bind a non-signatory affiliate of the contracting parties to the arbitration clause. As the name suggests, when arbitration agreement is entered into by one of the companies in a group, the other members of the group may be bound by the arbitration agreement if the facts and circumstances, including the conduct of the parties, indicate that the true intention of the parties was to bind the signatories as well as the non-signatories. So I feel that is the strongest statement, whether there was a true intent to bind them and they participated in the contract. The group of company doctrine first espoused explicitly by the arbitral tribunal in Dow Chemicals versus Isover St. Doven. The International Chamber of Commerce thereafter tribunal opined that the scope and effect of the arbitration agreement should be determined on the basis of common intent of the parties as ascertainable from the circumstances related to the conclusion, performance, and termination of the contract. The tribunal then determined that the Dow Chemical Group had not attached any significance to which of them performed the distribution agreements with Saint-Gobain, and the common intent of all the parties was they be playing a role in the performance of the contract. The tribunal further held that the companies within the Dow Chemical Group had acted as a single economic reality or unit, and that the non-signatories of the distribution agreement, the Saint-Gobain would be bound to the arbitration agreement regardless whether they had performed the contract. The tribunal in Dow Chemicals had laid down the elements which are required to track the group of company document, which read as follows. Irrespective of the distinct judicial identity of each of us members, a group of companies constitutes one and the same economic reality of which the arbitral tribunal should take account when it rules on its own jurisdiction. Considering that the tribunal shall accordingly determine the scope and effect of the arbitration clauses in question, and thereby reach its decision regarding jurisdiction by reference to the common intent of the parties to these proceedings, such as it appears in the circumstances that surround the conclusion and characterize the performance and later termination of the contracts in which they appear. Considering in particular that the arbitration clause expressly accepted
Performance and termination. Sorry.
Considering in particular that the arbitration clause expressly accepted by certain of the companies of the group should bind other companies which by virtue of their role in the conclusion, performance or termination of contracts containing the said clauses and in accordance with the mutual intention of all parties in the proceeding appear to have been veritable parties to these contracts or to have been principally concerned by them and by the disputes at which they may give arise. And group of company documents in foreign jurisdictions. It is important to recount the evolution of the group of company documents in France and other jurisdictions in order to understand some visible anomalies that have emerged in the Indian context. The practice by courts and tribunals in terms of usage of the group of company documents has gravitated towards being a fact-intensive exercise. In this context, what has emerged even in France, where the doctrine originated, is that the existence of a group of companies is not the sole sufficient condition for the joinder of a non-joinder to the signatory proceedings. The tribunal in ICC cases number so-and-so has summed up the steps in the application of the doctrine and held. Although the existence of a group is the first condition of joining a third party to the arbitration proceedings, it is also necessary to determine the party's actual intention at the time of the facts, or at the very least the intention of the non-signatory third party. Final award in ICC case number so-and-so elaborated as follows. The extension of an arbitration agreement to a non-signatory is not a mere question of corporate structure or control, but rather the use of the non-signatory's participation in the negotiations, conclusion, or performance of the contract, or its conduct towards the other party that the arbitral tribunal can refer. So each of these is or. It's not a. Each of these ingredients have to be there. At least some or one of these ingredients has to be there. Bernard Hannatu, arguably France's leading scholar on international arbitration, by referring to French jurisprudence, since that Dow Chemical opined that the existence of a group of companies gives a special dimension to the issues of conduct or consent. As several authors have pointed out, when there's a group of companies, one may presume that the parent company binds its subsidiaries. But on the other hand, only the companies that have been substantially involved in the negotiation and performance of the contract containing the arbitration clause will be considered parties to the latter. The case law is not always entirely clear in this respect. In most cases, it seems that only a substantial involvement is considered sufficient to constitute consent or ratification. Some cases, however, suggest that a party's conduct should not necessarily be regarded as an expression of a party's implied consent. Rather, a party's substantial involvement in the negotiation and performance of the contract and the knowledge and the existence of the arbitration clause have a standing of their own as a substitute for consent. Thus, the relevance of the group of company document in the jurisdiction of origin is that of being a special lens to which parties' intentions are interpreted. The existence of a closed group structure would only be one of the considerations when determining the implied consent of the third party to operate. Subsequently, the French court decisions have taken a similar stance. In so-and-so, the Cour de Cassation reiterated the requirement of involvement of the third party in the performance of the main agreement in order to be bound by the arbitration agreement contained therein. Similarly, the existence of a closely knit group of companies would be insufficient. In Society Alakal Business versus Society Acmore Technology, as well the Court of Cassation noted that the arbitral tribunal may bind non-signatories involved in the substantive dispute itself. In yet another ICC award, the tribunal held there is no general rule in French international arbitration law that would provide that non-signatory parties of the same group of companies would be bound by an arbitration clause, whether always or in determined circumstances. The reception to the group of company doctrine in other jurisdictions has been mixed. The Swiss federal law rejected the group of company doctrine, but has accepted that a third party may implicitly consent to be bound into arbitration in certain circumstances. In general, the involvement of the non-signatory in the performance of the contract will be interpreted as intent to be bound to the arbitration agreement. However, this requires an active involvement which shows clear and unambiguous intent, thus setting a high threshold for a third party to be joined. The Swiss sentiment vis-à-vis the group of companies doctrine is mirrored by the British jurisprudence, where there has been an unequivocal rejection of the doctrine. Further, the expression claiming through or under in Section 2.2 of the English Arbitration Act, which is similar to Section 8 of the amended Indian Act 96, has been interpreted to refer to instances that are unrelated to the group of companies doctrine. British courts have deemed it to mean inter alia assignees, subrogates, insurers, novates, and successors. American courts usually do not refer to the group of companies doctrine and rely primarily on the aspect of American contract law and agency law. Company law principles such as alter ego and piercing the corporate veil are additionally invoked by the American courts, though the threshold for their application remains relatively high. American courts have sometimes reached conclusions through reasoning that resembles the group of company doctrine, but which are actually based on the principle of equitable estoppel. The common theme among all these jurisdictions is that each of them has negotiated a compromise with a formalistic requirement of explicit assent through a signed contract. In other words, these jurisdictions have moved away from the need for explicit consent in each and every instance and have instead attempted to identify constructive consent via examination of the actions of the parties when the circumstances of the case requires it. In some instances, jurisdictions have even applied standards that are not based upon consent at all, such as equitable estoppel and piercing the corporate veil. Evolution of the group of company doctrine in India. Indian arbitral jurisprudence with respect to a binding non-signatory to an arbitration agreement has seen considerable transformation. In Sukanya Holdings versus Jagesh Pandya, certain disputes had arisen between multiple parties relating to the same transaction. However, not all the parties were signatories to the agreement containing the arbitration clause. The court, therein relying upon the unamended Section 8 of the Act, held that it would not be possible to refer to the non-signatories to arbitration. Thereafter, in Indo-Wind Energy versus Westacre, this court interfered with the order of the Madras court, which allowed the application under Section 11 of the Act and joined Indo-Wind to the proceedings, even though Indo-Wind was not a signatory to the agreement. This court, while allowing the appeal, held the very fact that the parties carefully avoided making Indo-Wind a party, and the fact that the director of Subsidiaries, who was director of Indo-Wind, was careful not to sign the agreement as on behalf of Indo-Wind, shows that the party did not intend that the Indo-Wind should be a party to the agreement. Therefore, the mere fact that Subsidiaries described Indo-Wind as its nominee or as the company promoted by it, or that agreement was purportedly entered into by Subsidiaries on behalf of Indo-Wind, will not make Indo-Wind a party. In the case of ratification, approval, adoption, or confirmation of the agreement dated 24/2/2000 by Indo-Wind. With utmost respect, it appears that the court in Indo-Wind adopted a rigid and restrictive understanding of the Act. In order to hold that a third party cannot be subject to the arbitration proceedings, the two-judge bench placed undue emphasis on the issue of formal consent. However, as noticed earlier, several jurisdictions have recognized that formal consent to an arbitration agreement is not sine qua non to adduce the mention of a third party to the bound to an arbitration agreement. In fact, certain principles by which courts across jurisdictions join non-signatories to the arbitration do not depend on the intent of parties at all. The principle laid down in Indo-Wind was then followed in S.N. Prasad versus Monet Finance and others as well. Eventually, this position of law regarding the joinder signatories was radically transformed after the decision of the court in Chloro Control, whereby the group of companies document was introduced to Indian jurisprudence. In that case, there was a shareholder agreement between an Indian party and a foreign entity. The shareholder agreement was the principal or parent agreement with the English law governing, and the transaction seat of arbitration is London. Beyond the shareholder agreement, there were various other interlinked agreements, but not all these agreements had the same parties. These other agreements, however, were part of a composite transaction. All rose out of the mother agreement. Question before the court whether all these parties could be referred to as a single and composite arbitral tribunal. Noting earlier precedent, this court stated that Sukanya holding was decided under the ambit of Section 8, that was the unamended 8. This case fell within the purview of Section 45 of the Act, which had a much wider scope, relying on the expression person claiming through or under in Section 45. This court held that it had the power to refer the parties to a multi-party agreement on arbitration while invoking the group of company document. It was further elucidated. We have already noticed that the language of Section 45 is that substantial variance to the language of Section 8 in this regard. In Section 45, the expression any person clearly refers to legislative intent to enlarging the scope of the words beyond the parties who are signatory to the arbitration agreement. Of course, such applicant should claim through or under the signatory party. Once this link is established, then the court shall refer them to arbitration. The use of the word shall would have to be given its proper meaning and cannot be equated with the word may as liberally understood in common parlance. The expression shall in the language of 45 is intended to require the court to necessarily make a reference to arbitration if the conditions of this provision are satisfied. To that extent, we find merit in the submission that there is a greater obligation upon the judicial authority to make such reference than it was in the comparison to the 1940 Act. However, the right to reference cannot be construed strictly as indefeasible right. One can claim reference only upon satisfaction of the prerequisites of Section 44 and 45, read with Schedule 1 of the 1966 Act. Thus, it is a legal right which has its own contours and is not an absolute free of any obligations to limitation. In other words, intention of the parties is a very significant feature which must be established before the scope of arbitration can be said to include the signatory as well as the non-signatory party. A non-signatory or third party which could be subjected to arbitration without their prior consent, this would only be in exceptional cases. The court will examine the exceptions from the touchstone of direct relationship of the party signatory to the arbitration agreement, direct commonality of the subject matter, and the agreement between the parties being a composite transaction. The transaction should be of a composite nature where the performance of the mother agreement may not be feasible without the aid and execution and performance of the supplementary ancillary agreements for achieving the common object and collectively having bearing on the dispute. Besides all this, the court would have to examine whether a composite reference of such parties would serve the end of justice. Once this exercise is completed and the court answers the same in the affirmative, the reference of even non-signatory parties would fall within the exception aforesaid. To give legislative effect to the decision of Chloro Control, the Law Commission in its 246th report made the following recommendation. The interpretation given by the Supreme Court follows the wording of Section 45, which recognizes the right of a person claiming through or under to apply to a judicial authority to refer the parties to arbitration. The same language is also to be found in Section 54 of the Act. The language is, however, absent in the corresponding provision of Section 8 of the Act. It is similarly absent in other relevant provisions where the context would demand that a party also include a person claiming through or under such a party. To cure this anomaly, the Commission proposed an amendment to the definition of party under Section 2H of the Act. The legislative wisdom did not amend the definition of Section 2(1)H of the Act, but Section 8 of the Act was amended through Section 3 of 2016, which now reads as follows. A judicial authority which an action is brought in a matter which is the subject matter of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him so applies, not later than the date of submitting its first statement on substance of the dispute, and notwithstanding any judgment, decree, or order of the Supreme Court or any court refer the parties to arbitration unless it does find prima facie no valid arbitration agreement exists. Following this post-amendment provision, the group of company document in Indian context was further expanded by a 3-judge bench of this court in Cheran Properties. This court invoked the group of company document and said, laid down that even though Cheran was not a party to the arbitration agreement and had not appeared before the tribunal, the arbitral award could be enforced against it, as Cheran was a party claiming under or one of the signatories to the agreement. Speaking on the importance of the doctrine in modern commercial transactions, the court held that the effort is to find true essence of the business arrangement and to unravel from a layered structure of commercial arrangements and intend to bind somebody who is not formally a signatory, but has assumed the obligation to be bound by the actions of the signatory. So this is what I said, that it has been expanded by, under Section 35, even enforcement against a party who is not a party to the arbitration itself. You can enforce the award if the circumstances are right against a party who not even participated in the arbitration. So the Chairman has expanded it enormously. In Recognizer versus Render Label Printing, this judgment I don't think was dealt with by Justice Ramana at any length. In Recognizer renders label versus printing, while acknowledging the group of company doctrine, the court refused to allow the joinder of a non-signatory, as it could not be proved that the non-signatory had negotiated the contract on behalf of the signatory. A two-judge bench of the court in Mahanagar Telephone Limited versus Canara Bank was concerned with the joinder of Canfina, which is a non-signatory to the agreement, but a wholly owned subsidiary of Canara Bank. Upon considering the nature of the transaction involved and the conduct of the parties, the court held that this was a case of tacit or implied consent, and accordingly it was necessary to join Canfina to the arbitral proceedings. The court stated that the principles governing the group of company doctrine follows. 10.7. The group of company doctrine has also been invoked in cases where there's a tight group of structure with strong organizational and financial links, so as to constitute a single economic entity or a single economic unit or a single economic reality. In such a situation, signatories and non-signatories have been bound together under the arbitration agreement. This will apply in particular when the funds of a company are used to financially support or restructure other members of the group. For instance, a three-judge bench of this court, which I remember, has, in a very recent decision, held in oil and natural gas versus method discovery, reiterated the deep-rooted existence of the doctrine in the Indian context. The court held that the following factors may be considered when deciding whether non-signatory arbitration.
Yes.
Reading paragraph 27, sir, a three-judge bench of this court, in which I was a member, has in a very recent decision in oil and natural gas company versus Messrs. Discovery Enterprises, reiterated the deep-rooted existence of the doctrine in Indian context. The court held that the following factors may be considered when deciding whether a non-signatory company within a group of companies will be bound by the arbitration agreement. 1. The mutual intent of the parties. 2. The relationship of a non-signatory to party which is a signatory to the new agreement. The commonality of the subject matter, the composite nature of the transaction, and the performance of the said contract. This broadly sets out the principles of which will be applied to decide whether the party was rightly joined to the arbitration or wrongly joined to the arbitration.
So 1 to 4 all under pre-contract.
Then paragraph D, current state of group of company doctrine.
Yes, Mr. Advani.
I'm muted.
We can hear you, Mr. Advani.
Sorry, sir. What I'm saying, so these are the 4 principles which are set out here, 5 principles, which really are the essence of the document. The mutual intent of the parties, the relationship of a non-signatory to party, which is a signatory to the agreement, the commonality of the subject matter, the composite nature of the transaction, and the performance of the contract. This sums up the group of company document. These 4 or 5 elements, or some of them are available, then they should be joined as a party. Current state of group of company doctrine. At the outset, it must be candidly acknowledged that certain inconsistencies do exist in the terms of judgments of this court regarding the underlying basis of the group of companies doctrine. For instance, in chloro control, the court seemed to adopt contradictory positions in terms of when a party may be bound to the arbitration agreement. On the one hand, the court emphasized on the intention of the parties to include a non-signatory party, But on the other hand, it went on to hold that the non-signatories may be added to the arbitration proceedings without their consent in exceptional cases. Thus, it seems that while thorough control places a premium on the intent of the parties, it also advocates taking on equity-based approach to discard intent completely if so required in the interest of justice. In Mahanagar Telephone, the court had applied the group of companies doctrine where a tight structure with deep financial organizational links existed between the signatory and non-signatory to the extent where they constitute a single economic unit. Such an approach has a tendency to overlook the principle of separate legal entity and seems to dispense almost entirely with intent and or consent of parties. It is also worth noting that in Cheran Properties, this court enforced an award against a party that had not even participated in the arbitral proceedings by relying on the phrase persons claiming through under them. In Section 35 of the Act, this presents the highest expansion of the group of companies doctrine, whereby a party is bound to the final award itself on the basis of the doctrine without having a chance to present its case or defending itself in the arbitral proceedings. The court in Rekit Beknaiser fixed a higher threshold of evidence of the group of company doctrine to apply as compared to the earlier judgments. Finally, in ONGC, the court has upheld the necessity for a deeper probe to determine whether the doctrine is attracted in the facts and circumstances of a given case. This leads to questions regarding which standard of proof must be fulfilled for the doctrine. An overall analysis of the above cited judgments reveals an unwitting but nonetheless discordant note with implicit contradictions. However, in my humble view, the appropriate response to such an uncertainty would be an authoritative determination of the contours of the doctrine rather than the wholesale uprooting it from the Indian arbitration law altogether. It is important to note that the doctrine has now traveled reasonable distance in Indian law. While the opinion of the Honorable Chief Justice correctly notes that the term parties under Section 2(1)H has not been amended, despite the changes introduced in Section 8 of the Act, it appears to me that one of the objectives in introducing the amended Section 8 was to accord tacit recognition and acceptance of the group company document in India. It may also be noted that the question as to which entities are parties to the arbitration agreement is usually left to the judicial discretion, especially when there's a limited statutory guidance. That the perception regarding the questionable sourcing of the group of company doctrine from the wording of Section 8 of the Act does not imply that it is barred from the Indian arbitration law. Undoubtedly, the courts have judicial discretion to invoke and apply doctrine to Indian arbitral proceedings. The earlier analysis of the interpretation of the group of company doctrine fortifies that, when formulated in its most modern sense, it does not affect the separate legal entity principle in company, how Gary Vaughan notes in his doctrine. Ordinarily, means of identifying the party's intentions which does not disturb or affect the legal personality of the entities in question. Rather, as usually formulated, the group of companies doctrine is akin to the principles of agency or implied consent, whereby the corporate affiliations among distinct legal entities provide the foundation for concluding that they were intended to be parties to the arbitration agreement, notwithstanding their formal status as non-signatories. Commentators have observed the same distinction between the group of companies doctrine and the veil-piercing principles. It therefore appears that the correct interpretation of the doctrine does not disturb or affect the separate corporate form of different entities within a group of companies. Neither does the act of piercing the corporate veil necessarily cause a separate legal entity of the third parties to collapse. In this context, corporate law doctrines such as piercing corporate veil and alter ego are a means by which to identify fraudulent activity by a non-signatory, which will then provide the legal justification for application of group of company doctrine to bind them and non-signatory to the arbitration. This is a departure from the single economic reality approach, which views the entire group of companies as a single entity and overrides the separate legal personalities of different members of the group. Thus, in this approach, the separate legal form of the parent company remains undisturbed, and the application of veil piercing or alter ego is merely for identification of duplicitous acts of a third party, which would then lead to application of the group of companies doctrine to bind them to arbitration. The function of this is to identify parties which have no actual intent to be part of the arbitration and deliberately use the corporate form as a shield to avoid being subject to arbitration proceedings. For such scenarios, a formal intent-based approach to group of company doctrine may be insufficient to address the dispute. From the analysis above, it appears that joining a third party to the arbitration based on the convergence of a group of companies as a single economic unit is no longer the norm under the group of companies doctrine. Instead, the standard is premised primarily on implied consent drawn from the acts and conduct of the entity within the group of companies. Where a closely knit group of companies exists, the interpretation of a third party intent to be bound to the arbitration will be construed from the facts and circumstances specific to that group and the manner in which it functions. This maintains the separate legal personality of the non-signatory and joins it to the arbitration proceeding on the basis of implied acceptance to be bound. It must be emphasized that the doctrine is an exception to the general rule of arbitration. However, where the facts of the case indicate that the intention of the parties was to bind the non-signatory, the courts, after exercising due care and caution, will be justified in invoking the doctrine to do substantial and complete justice. After the 2016 amendment to the Act, the court has continued to acknowledge and apply the doctrine to in exceptional cases. When all of these factors are viewed in consonance, it emerges that the doctrine was found to be firm footing in Indian jurisprudence. This is not without reason. On a practical front, the doctrine is a means of grappling with the complex multi-party business transactions, which necessarily involve more than two parties, even if these additional parties do not finally and formally sign the contract. To that extent, the doctrine helps to ensure the arbitration as a dispute resolution mechanism is able to adapt to this reality. Failure to do so would make the arbitration an ineffective dispute resolution forum, as parties which are important for the complete and proper resolution of dispute will be left out of the adjudication. The doctrine also ensures that multiplicity of proceedings are avoided. A party may be involved in the negotiation and even performance of the agreement, but still be able to circumvent the arbitral process on the ground that it did not sign the contract. Such a party then would have to be proceeded against in court. There are additional benefits of having the group of company doctrines in Indian jurisprudence. These arise from the peculiar circumstances and manner in which Indian businesses transact with each other and establish commercial relationships. A large chunk of Indian business now are composed of family-run entities or groups. The individuals running these entities often occupy multiple roles in different companies within the group. There's a commonality in terms of key managerial position, and the preponderance of family members occupying the position molds the way to these companies conduct business. Entering into commercial transaction involves an informal understanding based on familiarity with persons who run the overall group companies, even if not in specific not a specific entity which a contract is formally executed. May I just pause here for one moment to say, this happens in all group companies globally. It's not just in the Indian context of family-run companies. There are many family-run companies also internationally. And it's not dependent on family. Probably the chairman and the board of directors are directors in multiple subsidiaries. They operate and run the whole group as an entire group. So therefore, this, with all due respect to the learned judge, is not confined to an Indian situation. This happens as frequently in an international situation as an Indian situation, be it a family-run company or where there's a majority shareholder or a very strong chairman or a very strong board of directors. They run the entire group in this manner. This is not confined to an Indian situation in any manner at all. This applies equally in international arbitrations outside India. So then reading paragraph 42, in this scenario, it becomes even more relevant to have a doctrine such as a group of companies in Indian arbitration law. A third party outside the group of companies may transact with a subsidiary due to its faith in the bona fides and commercial know-how of the parent. The third party in question relies upon the stature or the presence of the larger parent company, either due to its reputation or personal familiarity with its promoters, directors, or executives. The doctrine itself may also provide greater stimulus for businesses and new entities that are starting out. Due to the aforementioned peculiarities in Indian business relationships, newer companies have significant difficulty in gaining traction. One of the means by which companies can gain a foothold is by being part of a large, often family-held group of companies. These entities are now able to feed off the goodwill or relations that the larger group has with the rest of the business world. Given that in the connection, larger group is intrinsic to the way in which business is conducted in arbitration law, must acknowledge and address this reality. In fact, the tribunals have already recognized the reliance that is often placed by a group company on the conduct of a non-signatory parent company when entering into the agreement with a subsidiary. The tribunals in Petro Alliance Services was.
Mr. Advanish, we continue after lunch. We are now almost towards the end of the judgment. We read the judgment. Now you can make your submissions based on the law, on the bare text of the statute, and then.
I just show your lordship one other Ontario court judgment on this.
Yes, we'll come back at 2 o'clock. You also have your lunch. Yes, Mr. Advani.
Yes, sir. I was on paragraph 33 of the judgment.
Yes.
Just to complete it, it may also be noted that the question as to which entities are parties to the arbitration agreement is usually left to the judicial discretion, especially when there's a limited statutory guidance. There's a perception regarding the questionable sourcing of the group of company doctrine from the wording of Section 8 does not imply that it is barred from Indian arbitration law. Undoubtedly, the courts have judicial discretion to invoke and apply the doctrine in Indian judicial arbitration, in Indian arbitral jurisprudence, sorry. The earlier analysis on the interpretation of the group of company doctrine fortifies, and when formulated in its most modern sense, it does not affect the separate legal entity principle in company law. Gary, as the doctrine,
It's already
Read already.
already read
34 we Gary Bond we read.
oh, sorry, sir.
You are actually 35, I think.
So just paragraph 35. It therefore appears that the current interpretation of the doctrine does not disturb or affect the separate corporate form of different entities within a group of companies. Neither does the act of piercing the corporate veil necessarily cause the separate legal entity of the third party to collapse. In this context, corporate law doctrines such as piercing the corporate alter ego are means by which to identify.
Advani, we read 41 also about, the family-run businesses, and then
I'm sorry, sir. I got my mark wrong.
only to India, but it also applies across the world. 42 completed. We'll go to 43 now.
We'll go to 43, sir. I'm sorry, sir. The doctrine itself may also provide greater stimulus for business with new entities that are starting out. Due to the aforementioned peculiarities in Indian business relationships, newer companies have significantly difficulty in gaining traction. One of the means by which such companies can then gain a foothold is by being part of a large, often family-owned group of companies. The new entities are then able to feed off the goodwill or relations that larger companies have with the rest of the business world. Given that the connection to larger groups is intrinsic in the way in which business is conducted, arbitration law must acknowledge and address this reality. In fact, the tribunals have already recognized the reliance that is often placed by a company upon the conduct of the non-signatory parent company when entering into the agreement with a subsidiary. The tribunal in so-and-so, under the aegis of Arbitration Institute of Stockholm and Chamber of Commerce, is a prime example of international arbitration grappling with this issue. Therein, the Arbit Tribunal noted that the UCOS oil, with its Wyeth action, had created an expectation in the mind of Petro Alliance that were willing to and ready to back up, step into the places of its subsidiary YNG, with which Petro Alliance had entered into a contract. While there were several factors that contributed to the decision of the tribunal to bind UCOS to the arbitral proceedings, the most relevant takeaway for our purposes is the manner in which the tribunal enunciated the theory of trust that exists under Swedish contract law. The important consideration of theories similar to the company law principles, such as an alter ego, is not the actual intent of the party as a non-signatory, may be acting duplicitously or to represent itself as the driver of the contract while avoiding any liabilities arising from it by not signing the contract. Hence, what the theory examines is that the intent the non-signatory has conveyed to a reasonable party in the same position as the contracting entity. The decisive factor is the extent to which the contracting party has placed trust in the other party reasonably and on the basis of non-signatory action. To clarify, the wholesale adoption of Swedish theory of trust into Indian law is not being advocated. Rather, the notion of how we may apply the group of company doctrine in situations when non-signatory parties are acting in a fraudulent or deceitful manner can be addressed by examining the impression that was conveyed to the contracting parties by the third party. This is the addition to the already well-established principles of piercing the veil and alter ego. This may also address a legitimate critique of chloro controls and Cheran properties that despite placing an emphasis on legal standards of intent, the court eventually resorted to the principles of equity, commercial, stroke economic expediency to apply a group of companies doctrine in those cases. Conclusion. In view of the above discussion, respectfully, I am of the opinion that the questions that are sought to be referred to a larger bench deserve further elaboration. With all humility at my command, the following substantial questions of law also arise for authorities for determination by a larger bench in addition to the conjunction with those formulated by the Honorable Chief Justice.
It seems to have started today.
Yes.
A. Whether the group of company doctrines should be read into Section 8 of the Act or whether it can exist in Indian jurisprudence independent of any statutory provision. Whether the group of company doctrine should continue to be invoked on the basis of the principle of single economic reality. C. Whether the group of company doctrine should be construed as a means of interpreting the implied consent or intent to arbitrate between the parties. D. Whether the principle of alter ego and or piercing the corporate veil can be alone justify pressing the group of companies doctrine into operation even in the absence of implied consent. So may I just show one other judgment, a very small part of it. It's an Ontario court judgment which talks about the model law.
Mr. Advani, now why don't we look at the matter as a matter of first impression, and you can develop it from the statute, then show us some of the law, including some of the judgments of our court, and you can then make your submissions. That may be a good idea, because instead of us looking at just comparative law without looking at our own statute, may be a little problematic. So let's look at our statute, see how you want to evolve the doctrine of this doctrine, the group of companies doctrine, in the context of our statute. Where do you really found that doctrine? How do you sort of read that doctrine into the statute?
So as I indicated, first,
8 and 45 may not really be relevant, because 8A applies to the party which is seeking a reference to arbitration. Likewise, 45 applies to a party or party claiming fruit which is seeking a reference to arbitration. Whereas the group of companies doctrine also applies to a situation where you are seeking to hold, apart from your counterpart, the counterparty, someone else as liable under the contract, apart from the signatory to the agreement. So 8 and 45 in that sense, so the amendment to 8 may not be to that extent very material. Of course, it's broadly an indicator that they brought 8 at par with 45 when in the 2015 amendment. But how do you now look at the statute? First, tell us, how do you look at the statute and then interpret it?
So may I just,
do one each, yes.
for that, I draw your attention first to the Article 2 of the New York Convention, sir.
To the
New York Convention wants to show us.
Should we not look at the statute, the Indian statute straight away?
Very well. So then if we go to section 7, sir, for a moment.
7, 8, and 2.
Let's look at section 2 first.
I'll go to section 2 first, sir. So 2 is definition. In this part, unless a contract otherwise requires, arbitration means any arbitration, whether or not administered by a permanent arbitral institution. Arbitration agreement means an agreement referred to in section 7. Then, so the relevant definition here will be of, just give me one moment, the party.
Yes.
I'm just giving party, the 218, sir.
Yes.
Party means a party to an arbitration agreement. So,
Yes.
just pausing you for a moment, sir. What the Law Commission's opinion.
It's very interesting. It says party means a party to an arbitration agreement.
Yes,
The
sir.
party in the first part cannot be equated with the party of the second part, isn't it? Or does it mean the same thing?
And so, therefore, what the Law Commission expressed its view.
What do you mean by party? Party in 21H, does party, I mean, reading it in a very strict sense, it will mean a signatory to an arbitration agreement.
Intent.
If you were to read it in a strict sense,
sense.
very strict sense.
So,
Someone will execute the
if you
arbitration.
see, So if you see the wording doesn't use the word signatory.
Right, exactly.
It doesn't.
That's what you're right. That's
It
exactly
means
the point I was
So
saying.
party
there's
to an
an
arbitration
implied
agreement.
party is what you're saying.
Yes.
And therefore, so the Law Commission, when it was giving its opinion, also expressed the view that the party should not be construed narrowly, but it means anybody who is, in that sense, consented to the agreement or acted on the agreement. It should not be construed narrowly. This is the opinion given by the Law Commission.
And nevertheless, the expression there, it doesn't require an interpretation. If you just read this statute as it stands, party to an agreement. So obviously a party who has signed the agreement, I mean, we are just looking at this particular provision right now.
I presume, well, what if he impliedly consented to the agreement, sir?
Alright,
If a party has impliedly consented
a signatory to an agreement or the executant of the agreement would be a party. That is very clear.
Yes, sir, but it is not confined to that. That is why the definition of party, as suggested by the Law Commission, was that it would include anybody who's impliedly consented to the agreement. It is an implied consent, it is also a party.
Where does the Law Commission say that?
If you see Justice Ramana's judgment, he quotes the Law Commission on that.
Do we have the Law Commission report here?
I have it, sir.
Yes, ma'am. It's
Just give me one moment, sir.
starts from page 270 of the compilation. And
270 of the compilation. Okay.
the relevant paragraph starts from page number
Convenience company.
307 only.
307. 30.
Para
Yes,
60.
sir.
This is convenience compilation by Mr. Divakant Lavati, right?
Come back with the page again.
The Law Commission report starts from page 270.
So the relevant page is 307, sir.
PDF 309.
Yeah.
So if it's PDF
Definition of party.
9 PDF. Which report was this? Rishi मिल गया आपको?
309.
PDF page 309. Jamshid, you got it?
309.
PDF page, madam.
Manoj, you got page 309.
Definition of party is what you are at?
Yes.
Yes.
Yes, sir. Yes, sir.
Yeah,
309.
Do we all have it? So my paging is 307.
All right. You mean the page on the right hand side?
Yes, sir. Page on the right hand side.
Yes, we got it.
It's paragraph 61, definition of party.
Yes, please read it out.
Do we all have it, sir?
Yes.
May I just read? Arbitration is a consensual form of dispute resolution with the arbitral tribunal deriving powers and authorities on the basis of the contract or the agreement between the parties. This agreement has far-reaching consequences. It takes away the right of the party to the arbitration agreement for various remedies in a court of law for resolution of the disputes covered by the terms of the arbitration agreement and makes the consequences of the award binding with a limited right of recourse in terms of Section 34 of the Act. It would thus be incongruous and incompatible with this consensual and agreement-based status of arbitration as a method of dispute resolution to hold persons who are not party to the arbitration to be bound by the same. However, a party does not necessarily mean only the signatory to the arbitration agreement. In appropriate context, a party means not just a signatory, but also persons claiming through or under such signatory. For instance, successors of interest of such parties, alter egos of such parties, etc. This is particularly true in the case of unincorporated entities, where the issue of personality is usually a difficult question and raises a host of other issues. This principle is recognized by the New York Convention 1985, which in Article 2.1 recognizes an agreement between the parties in respect of a defined legal relationship, whether contractual or not. The Arbitration and Conciliation Act 1966 under Section 7 borrow the definition of the arbitration agreement from the corresponding provision at Article 7 of the Universal Model Law, which in turn borrowed this from Article 2 of the New York Convention. However, the definition of the word party in Section 2(1)(h) refers to a party to mean a party to an arbitration agreement. This cannot be read restrictively to imply a mere signatory to an arbitration agreement, since there are many situations and contexts where even a non-signatory can be said to a party to an arbitration agreement. This was recognized by the Honorable Supreme Court in Cloro Control versus Swen Trent Verification, where the Honorable Supreme Court were dealing with the scope and interpretation of Section 45 of the Act, and in that context discussed the scope of the relevant doctrines on the basis of which a non-signatories could be said to be bound by the arbitration agreement, including in cases of interrelated contracts, group of companies doctrine, etc. This interpretation given by the Honorable Supreme Court follows from the wording of Section 45 of the Act, which recognizes the right of person claiming through or under a party to apply to the judicial authority to refer to the parties to arbitration. The same language is also used to be found in Section 54 of the Act. The language is, however, absent in corresponding provision of Section 8 of the Act. It is similarly absent in other relevant provisions where the context would demand the party also include the person claiming through or under such a party. To cure this anomaly, the Commission proposed amendment of the definition of party under Section 2(h) of the Act. So the Commission recognizes a broader definition, and they say, just to, so to speak, close the gap, we recommend an amendment to 2. That 2 was not amended, but
Let
they
us see
recognize.
7.
Now we'll go to 7.
7, C7, very important. The definition must be read in the context of 7.
Yes, sir. Arbitration agreement. In this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. These are the same words taken from the New York Convention. And so some meaning must be attributed to the defined legal relationship, whether contractual
Please read
or not.
further.
Just read on, just read
Please
on,
read on, it's very important because express is important.
An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. An arbitration agreement shall be in writing.
That's it.
An arbitration agreement is in writing if it is contained in a document signed by the parties. An exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic means, which provide a record of the agreement, or an exchange of statements of claim and defense, in which the existence of arbitration of the agreement is alleged by one party and not denied by the other. A reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing and the reference is such to make the arbitral clause part of the contract.
So if a arbitration agreement does not contemplate a particular party, can we still say that it's an arbitration agreement?
Yes, sir, that's what the Section 2 says. Section 2 says that an arbitration agreement may be in the form of an arbitration clause, a contract, or in the form of a separate agreement. So all that it contemplates is a written agreement.
But that will not help you because it need not be in that it may be in the form of an arbitration clause in a contract or in a separate agreement.
That's
But
right.
it has to be an
But it does
agreement in writing.
This is departure from the Contract Act, which contemplates the existence of an agreement which can be implied also. So Arbitration Act does away with that and says an arbitration agreement must be a written arbitration agreement. So now once an arbitration agreement is a written agreement, is it possible for a court to infer inclusion of a third party in the agreement by implication?
So that's why, sir, in the definition of party, it can be implied by, it can be by implied term. It does not have to be a signatory to the contract.
Also something in say 4B So when 4B says an arbitration agreement is in writing if it is contained in B, an exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic means, which provide a record of the agreement. So if there is a written course of written communication between the parties, by virtue of which a party which is otherwise not a signatory to the agreement has evinced an intent to be bound by the arbitration agreement, then possibly then...
And C5 also. The reference to a contract.
To a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing and the reference to such is to make arbitration clause part of the contract. So there are...
So one thing, Mr. Advani, is very clear that can you say that a third party which is not a signatory to a written agreement would be bound merely by conduct
Or correspondence.
Then there is actually a
Unless it is.
Say,
agreed correspondence?
You see, conduct, as the Learned Chief Justice has pointed out, not only just conduct, but correspondence, as it is pointed out in clause 4B, but which provide a record of the agreement. That has to be also satisfied. After all, these are all commercial transactions. I mean, somebody who you expect to fulfill a part of the contract has actually committed to fulfill that part of the contract, and yet you don't insist on an agreement.
I appreciate that, sir.
Hard-nosed commercial contract. I mean, you are asking, for the arbitration to trigger in that implied agreement, etc.
So therefore, sir, what I was going to suggest is 7.1 is a governing clause, sir. 7.1 is the overall governing clause, which goes on to say that this part of the arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen, which may arise between them in respect of a defined legal relationship, whether contractual or not.
Now, interestingly, the Law Commission recommended that 2H should also be amended, which was never amended, at par with 8.
But sir, the Law Commission in paragraph 62 on page 308 goes through this whole exercise and in terms says, however, party does not mean only a signatory to the arbitration agreement. And that's a general view taken by the Law Commission, sir. Although they said to close the loophole, we suggest clause 2 also be amended.
They also relied on chloro control.
They also relied on chloro control.
The correctness of chloro control is now at large before us.
I appreciate that they relies on chloro control, sir, and
because they say it does not only mean a signatory. That you are right, because if the legislature wanted to use the word signatory, they would have used the word signatory.
Right.
Into 1H. So the absence of the use of the word signatory and a reference to a party to the agreement is of some significance. But equally, then you have to read it in the context of 7, because 7 specifically says that it has to be an agreement in writing.
So this is clearly departure from section 10 of the Contract Act, which qualifies the definition of an agreement evolving into a contract, and says that it need not be a written agreement specifically.
Therefore, suit for specific performance of an agreement to sell can be a suit for specific performance of an oral agreement to sell as well. There is no requirement in law that your contract of which performance is sought is a written contract.
May I just point out, just on a side, most of this concept of group company documents have originated from awards. They have not originated from interpretation by the agreement by the courts. Find that page of discovery was.
Yeah.
He's not in.
You should tell us why the Law Commission recommendation, so far as the definition is concerned, was not
2H.
carried out. 2H. Because somebody must convey it to him.
So may I,
Was it overlooked or was it something deliberately they didn't?
Yes, but separately, I'll make my submissions.
so may I just draw your attention to one judgment of the Supreme Court which has considered this issue.
All right.
This is the decision of MTNL versus Canara violation. It starts at page 158 and it considers these issues on from
PDF
page
160. MTNL.
166.
It's MTNL versus Canara Bank,
Yes, Manoj.
Just Hindu Malhotra. Yes.
page number 166, Maharaj, para 9 on.
We got it.
The existence of a valid arbitration agreement.
Yes, Mr.
So if we go to the judgment of MTNL versus Canara Bank, on page 166 of our compilation, paragraph 9. A valid arbitration agreement constitutes the heart of an arbitration.
Page 166.
Page 166, paragraph 9.
Yes.
A valid arbitration agreement constitutes the heart of an arbitration. An arbitration agreement is a written agreement between the parties to submit the existing or future disputes or differences to arbitration. A valid arbitration agreement is the foundation stone on which the entire edifice of the arbitral process is structured. A binding agreement or disputes to be resolved through arbitration is sine qua non for referring the parties to arbitration. Section 7 defines the arbitration agreement as under. I'm not reading the definitions as we've just seen it. If we go to the next paragraph 9.2, the arbitration agreement need not be in any particular form. What is required to be ascertained is the intention of the parties to settle their disputes through arbitration. The essential elements or attributes of an arbitration agreement is the agreement to refer their disputes or differences to arbitration, which is expressly or impliedly spelled out from a clause in an agreement, separate agreement, or documents correspondence exchange between the parties. Section 7.4 states that the arbitration agreement can be derived from an exchange of letters, telex, telegram, or other means of communication, including through electronic means. The 2015 Amendment Act inserted the words including communication through electronic means. In section 7.4b, it can prima facie be shown that parties are ad idem, even though the other party may not have signed the formal contract, it cannot absolve himself of liability under the agreement. Arbitration agreements are to be construed according to the general principles of construction of statutes, statutory instruments, and other contractual documents. The intention of the parties must be informed from the terms of the contract, conduct of the parties, and correspondence exchange to ascertain the existence of a binding contract between the parties. If the documents on record show that the parties were ad idem and had actually reached an agreement upon all material terms, then we construe to be a binding contract. The meaning of a contract must be gathered by adopting a common sense approach and must not be allowed to be thwarted by a pedantic and legalistic interpretation. A commercial document has to be interpreted in such a manner so as to give effect to the agreement rather than to invalidate it. An arbitration agreement is a commercial document in the parties and must be interpreted so as to give effect to the intention of parties rather than to invalidate it on technicalities. In so-and-so case, the court, while ascertaining the terms of an arbitration agreement between the parties, held that if on a reading of the documents as a whole, it can be fairly deduced from the words actually used therein that the parties had agreed on a particular term, then nothing in law which prevents them from setting up that term. The terms of the contract can be expressed or implied from what has been expressed. It is an ultimate analysis, a question of the construction of the contract. In interpreting or construing an arbitration agreement or arbitration clause, it will be the duty of the court to make the same workable within the permissible limits of the law. This court in so-and-so held that a common sense approach has to be adopted to give effect to the intention of the parties to arbitrate the disputes between them, being a commercial contract. The arbitration clause cannot be construed with a purely legalistic mindset, as in the case of a statute. In this case, MTNL raised a preliminary objection that there was an arbitration agreement in writing between the parties. At this stage of the proceeding, we will deal first with this issue. The agreement between MTNL and Canara Bank to refer the dispute to arbitration is evidenced among the following documents exchanged between the parties in the proceeding. So those are the facts of that judgment. So I won't trouble you with that one, sir. So if you go to the relevant page on
198 discovery.
no, on this judgment. Then if you go to paragraph 10, sir, joinder of Canfina and the arbitral proceedings. Canara Bank raised an objection to the joinder of respondent number 2 Canfin as a party to the arbitration proceedings. As per the principles of contract law, an agreement entered into by one of the companies in a group cannot be binding on the other members of the same group, as each company is a separate legal entity which has separate legal rights and liabilities. The parent or the subsidiary company entering into an agreement, unless acting in accord with the principle of the agency or representation, will only be an entity in the group to be bound by that agreement. Similarly, in arbitration is also governed by the same principle, and normally the company entering the agreement will alone be bound by it. A non-signatory can be bound by an arbitration agreement on the basis of group company document where the conduct of the parties evidences the clear intention of the parties to bind both the signatory as well as the non-signatory parties. Courts and tribunals have invoked the doctrine to join a non-signatory member of the group if they are satisfied that the non-signatory member of the group or by reference to a common intention of the parties a necessary party to the contract. So what is being suggested is to interpret all this in a commercial manner. And if you see where the origin of where did the origin of the group company comes, it came in through arbitration awards, not through court judgments. When the arbitral tribunal in the Dow Jones case comes first to a conclusion that, look, this is because of the way Dow Jones is constructed as a group, that they can be made parties to the arbitrations, the court then affirmed that principle. Even in the Ontario judgment, which I was going to show your lordship, there was again an interpretation of the arbitration award that one of the other parties is rightly by the arbitration agreements. And then they deal with the uncitral law. It says the uncitral law is meant to decide dispute between the parties in an expeditious manner. Therefore, the interpretation must be more liberal, and therefore we hold the award is right. So the origins of some of these situations did come from the facts of the case and sometimes considered by the arbitral tribunal, and said it is appropriate that people are implied members or they participate in the contract or they're acting together, and then the courts have upheld the principle. So even Justice Malhotra, when she takes the view, please treat these as commercial documents and read them in a commercial manner and not in a legalistic and tight manner.
On party.
Therefore, the article of the New York Convention and Section 7, which override, say whether contract define relationships, whether contractual or not. They use those very wide words to enable courts to consider whether in an appropriate case or not it should be done. And that, in fact, was ultimately going to be one of my propositions to your lordships, that your lordships, when deciding a section 11 or 8, where this is the parameters are the same, will take a prima facie view. Have all the parties, have they participated in the contract either by conduct, intent, or different manner financially? We'll take a practical view and then leave the details to the arbitral tribunal to decide. Because ultimately they are subject to Section 16 applications. The courts will take a prima facie view, a broad view of the definition of party. The court will take a broad view of the courts will take a broad view of the definition of party. The Law Commission has taken a particular view. If you look at Section 17, they also say contractual or define relationship, whether contractual or not. And that it should be the discovery thing. Paragraphs.
Chetan?
So may I show your lordships quickly one? May I show your lordships one more judgment, Vinod?
Yes.
This is the Discovery Enterprises on page 198. The relevant portion is on page 198 of my compilation.
And also show us this Charan.
I'll come to Charan. So I'll just finish with this and I'll come to Charan after that. Your lordships have page 198.
Yes.
May I just read from paragraph 20, sir? Section 7 provides for an arbitration agreement. For the purpose of the agreement.
Just a minute,
Yes.
just a minute. Your pages, there's a bit of a.
It's actually 200. Page 3.
Just a minute. Yes.
Did your lordships have it? It's paragraph 20. Group of companies doctrine. Section 7 provides for an arbitration agreement. For the purpose of part 1 of section 1996, the arbitration agreement defined to be an agreement between the parties to submit disputes between them in respect of a defined legal relationship to arbitration. An arbitration agreement may either be in the form of an arbitration clause in a contract or take the form of a separate agreement. An arbitration agreement has been in writing, but it may be contained in. So then we are quoting that. Then we go to paragraph 21. Section 5 of the section 7 stipulate that the reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is written and the reference is such as to make the arbitration clause a part of the contract. The expression party is defined in section 218 in a party to an arbitration agreement. The interpretation of the term parties will be an arbitration agreement under section 7 as we dealt with by this court, by this court in Indo-Wen in the context of application for the appointment of the arbitrator under section 11.6. In that case, the second respondent was the promoter of Indo-Wen. The first and second respondent entered into an agreement for sale. In the agreement, the seller was described to include the respondent and his subsidiaries. The second respondent was described as the buyer and as the promoter of the Indo-Wen. Under the agreement, the seller agreed to transfer the business of assets for consideration, which was partly payable in money and partly by the issuance of shares. The sale agreement also incorporated a clause to arbitrate any dispute. The board of directors of the first and second respondent approved the agreement, but there was no approval by the board of Indo-Wen. After a dispute arose, the first respondent instituted a petition under section 11.6 against both the second respondent on the ground that was not a party to the argument between the first and the second respondent. The application was allowed by the Chief Justice of the Madras High Court by observing that prima facie Indo-Wen was a party after lifting the corporate veil and noticing Indo-Wen's intention to be bound by the sale. Two issues were framed by the court for consideration, so and so. So then paragraph 23 is the relevant one. R.B. Ravinan J, speaking for the judgment in Indo-Wen, held that if Indo-Wen had acknowledged or confirmed in any correspondence, agreement, or document that was a party to the arbitration agreement between the first and second respondent, or that was bound by the arbitration agreement contained in the contract, it would have been possible to say that Indo-Wen is a party to the arbitration agreement. Your Lordship, remember, this was before the amendment.
Yeah.
The judge expressed this view. The learned judge expressed the view before the amendment to Section 8, saying that if there was any correspondence or anything of that sort saying it was party to the contract, then it could be construed to make them a party to this arbitration. But because of the lack of correspondence, etc., it could not be done. And don't forget, this was before the amendment to Section 8. It could have been possible to say that Indo-Wen is a party to the arbitration agreement. That, however, was not the position. The decision Indo-Wen was in context and application under Section 11.6 a party with. So therefore, so the
think third.
So I was just pointing out that observation that even half the partial property.
Yes, Mr. Advani.
Now, in the same judgment, could your lordships go to paragraph 29 where Cheran properties is considered?
Right.
In Cheran properties, a three-judge bench of this court.
You said that 29.
It's on page 202 of our compilation, sir. In Cheran property, the three-judge bench of the Supreme Court interpreted and applied the group of company doctrine in the context of the enforcement of a domestic arbitration award against a non-signatory to the arbitration agreement. The court observed that the decision by the two-judge bench in Indo-Win was rendered before the evolution and application of the group company doctrine by a three-judge bench in Cloro Control. As the law has evolved, it has recognized that modern business transactions are often effectuated through multiple layers and agreements. There may be no transaction within a group of companies. Circumstances which they've entered into may reflect an intention to bind both the signatory and the non-signatory entities within the same group. In holding a non-signatory bound by an arbitration agreement, the court approaches the matter by attributing to the transaction the meaning consistent with the business sense it was intended to be ascribed to them. Therefore, factors such as the relationship of a non-signatory to a party which is a signatory to the agreement, the commonality of the subject matter, and the composite nature of the transaction weigh in the balance. A group of company document is essentially intended to facilitate the fulfillment of a mutually held intent between the parties. Where the circumstances indicate that the intent was to bind both signatories and non-signatories, the effort is to find out the true essence of the business arrangement and to unravel from a layered structure of commercial arrangements and then to bind someone who is not formally a signatory but has assumed the obligation to be bound by the actions of the signatory. This court in Cheran properties also analyzed the academic literature and scrutinized the adjudicatory trends across the world. They noted that the retained intention to arbitrate between the parties can extend to bind non-signatories with the aim to target a credit-worthy member of the group of companies. However, the principle of separate legal personality of the company also has to be balanced. The corporate world can be pierced to bind non-signatories upon a construction of the arbitration agreement, the intention at the time of entering into the contract, and the performance of the underlying contract. Does the requirements of Section 7 that an arbitration agreement be in writing exclude the possibility of binding third parties who may not be signatories to an agreement between the two contracting entities? The evolving body of academic literature, as well as the adjudicatory trends, indicate that in certain situations, an arbitration agreement between two or more parties may operate to bind other parties as well. Redfern Hunter explained the theoretical foundation of this principle. The requirements of signed agreement writing, however, does not altogether exclude the possibilities of an arbitration agreement concluded in proper form between two or more parties also binding other parties. Third parties to an arbitration agreement have been held to be bound or entitled to rely on such an agreement in a variety of ways. First, by operation of the group of company doctrine, pursuant to which benefits and duties arising from the arbitration agreement may in certain circumstances be extended to other members of the same group of companies. And secondly, by operation of general rules of private law, principally on assignment, agency, and succession. The group of company doctrine has been applied to pierce the corporate veil, to locate the true party and interest, and more significantly, to target the creditworthy member group of companies. Though the extension of the doctrine is met with resistance on the basis of legal imputation of a corporate personality, the application of the doctrine turns on a construction of the arbitration agreement and the circumstances relating to the entry into the performance of the underlying contract. This court in Cheran properties also distinguished the principle laid down in Cloro Control from its application in this context of Section 11 and so judgment. The bench of the court refused to direct a joint arbitration in 5 different contracts between sister companies of one of the parties of the original arbitration agreement by respecting the conscious intentions of the parties to subject themselves to separate arbitration agreements under the individual contracts. The court in Cheran properties distinguished the actual situation by discerning the mutual intention of the parties and the performance of the contract. The principle which underlies Cloro Control is that an arbitration agreement which is entered into within a group of companies may bind non-signatory affiliates. The circumstances are such as to demonstrate the mutual intention of the party to bind both signatories and non-signatories. In applying the doctrine, the law seeks to enforce the common intention of the parties, where circumstances indicate that both signatories and non-signatories were intended to be bound. In Juro, the case was held to stand on a different footing since all 5 different packages as well as corporate guarantees did not depend on the the terms and conditions of the original package, nor on the memorandum of understanding executed between the parties. The judgment in Euro does not detract on the principle which is enunciated in law of control. A group of company doctrine was subsequently applied by the judge bench of this court in Beckett, Beniska versus Reinders for deferring of if a non-signatory to a foreign company when the same group of companies could be impleaded in a domestic arbitration. The court noted the principles formulated by this court in Florida Controls and Cheran Properties and noted its inapplicability after assessing the following. The alleged common employee between the two companies in the same group was factually established as having no connection with the foreign company. A mere existence of an indemnity by a foreign company in the absence of other factors would not signify the intention to be bound by the arbitration agreement and not deriving benefits from the performance of the underlying contract. In MTNL 2, a judge when the court was considering a situation in which MTNL floated certain bonds to Can Bank Financial Service Limited, Canfina, through a memorandum of understanding. The bond amount was placed in FT by MTL with Canfina. Canfina paid back part of the amount of the FT, while the rest was not paid to MTNL. The consequence, the MTNL did not service the interest on the bonds. Okay, Your Lordship says that the courts have dealt with the concept of agreement and parties both. Both Section 2 and Section 7 have already been interpreted by the courts, and they said because these are commercial contracts, are interpreted broadly. And in interpreting them broadly, they have seen there are certain circumstances where it is appropriate to apply the group company document, and in certain circumstances it will not be applied. So the question that comes before Your Lordship is, when should this be done? When Your Lordship is either sitting in either Section 11 or 8 to arrive at a prima facie view, it's obvious that the other company was involved. That's the first we can see. And then let the arbitrator decide the realities of the situation, whether it's through evidence, whether it's through
Mr. Advani, this principle of prima facie would not be of any help here, because you are making somebody a party to the proceedings. That's the call that the Section 11 court will take when an application is made. So to be made a party or not to be made a party is final.
And it's not final. Your Lordship would appreciate that the party, if he feels is inappropriately made, is the prima facie.
Are you suggesting that after a court takes a decision as to a third party should be made part of the agreement and matter be referred to arbitration, and thereafter the arbitrator will take a decision as to whether he is necessary party or not? Is there a second stage like that of what has been provided in other judgments? Section 11 stage.
With all due respect, what that earlier judgment of withdrawal Viola says, that the court should take a prima facie view, and then a party is not bound, the arbitrator is not bound, because the party can take out an application under Section 16 and say, I should be discharged. It is open to him to take out an application under Section 16, say, that is a prima facie view taken by the court. That's correct. I'm before you. I'm appearing before you. But I have a right to satisfy you. In fact, I have nothing to do with this contract at all. I'm not connected with it anyway. And that is a decision under Section 16 the arbitrator can take. He's not in any sense overruling a court decision. The Lordship will see that the courts have repeatedly said that for Section 11 or 8, take a prima facie view.
Section 11 decision, whether these
Should be Section 16 of the I.
Yes, Mr. Advani.
Yes, my lord.
Yes.
Now, therefore, I'm saying your lordship seen that video, Jola. That is why the lordships apply the same standard, saying take prima facie view on section 8 and 11. If there's an arbitration agreement, once the court finds an arbitration agreement, parties are referred to arbitration. Then the arbitral tribunal can go into the issue whether one of them is a proper party or not a proper party to the arbitration.
But at the section 11 stage, how does the court determine as to whether a third party will be bound? You are saying it will be a prima facie determination?
Yes, my lord. Otherwise, that is the role of the arbitrator. There may be evidence to decide one way or the other.
Exactly.
That's right.
The arbitrator may consider evidence of all the correspondence.
Therefore, the 11 court can't decide this at all. I mean, the 11 court cannot then go into render a final determination.
Correct.
Or a conclusive determination.
With all due respect, the court will determine on a petition and an application without seeing the evidence. Some evidence, prima facie evidence, your lordship will look at correspondence. But if there's oral evidence on this issue, your lordships are not going to go into oral evidence on 11 to consider whether it's right to put the parties in the arbitration or not. If we say that they made all sorts of commitments, they made all kinds of oral commitments, and the arbitrator will come to findings of fact on that. That is why your lordship see that decision of Video Jola, which I'm not carrying with me, where they say take a prima facie view on this.
Is Drolia part of your compilation?
No.
No, sir, but it was quoted in Justice Ramana's judgment. If I may just take that out, sir.
We'll take Dolia.
We'll pull it out.
We'll pull up with your.
Just give us a citation of Dolia from Justice Ramana's judgment.
I'll just give it in a minute, sir. Just give one.
It was 2021, 2 SCC, page 1. 2021, 2 SCC, page 1.
If your lordship sees Justice Ramana's judgment, paragraph 42. Your lordship have just paragraph 42 of Justice Ramana's judgment. Lordships will see paragraph 239 and 240 of that judgment of Video Jola.
Para
239 and 240. That has been quoted by Justice Ramana also, but
no, that is we'll have to see Justice Sanjeev Khanna's judgment. That is.
yeah, I appreciate that. If your lordship will look at para 239 and 240 of the Video Jola judgment.
That's a concurring judgment.
In 239, he says in terms. In a multi-party arbitration, there is complicated factual questions which are best left for the tribunal to handle. And in 240 also, sir. They take a prima facie view.
Finality. Since para 20. Online judgment. But yeah. Just page 147.55, 147. I think it's here. This is
The Lordship will see also paragraph 231 with the recommendation to the Law Commission, sir.
Yes, yes. You are referring to Mr. Advani, Justice Ramana, 238 and 239.
And 231 also, so the Law Commission recommendation, if I may read it, sir.
Yes.
Paragraph 231, the 246 Law Commission report in respect to the scope and nature of pre-arbitral and judicial interference states as under. The Act recognizes situations where intervention of the court is envisaged in the pre-arbitral stage, i.e. prior to the constitution of the arbitral tribunal, which includes section 8, 9, 11 in case of part 1 arbitration and section 45 in case of part 2. Section 8, 45 and section 11 relating to the reference to arbitration appointment of the tribunal directly affect the constitution of the tribunal and the functioning of the arbitral proceedings. Therefore, the operation has a direct and significant impact on the conduct of the arbitration. Section 9 being solely for the purpose of securing interim relief, although having the potential to affect the rights of the party, does not affect the conduct of the arbitration in the same way as do the other provisions. It is also in the context the Commission has examined and deliberated the working of these provisions and proposed certain amendments. The Supreme Court has occasion to deliberate upon the scope of and nature of permissible pre-arbitral judicial reference, especially in the context of Section 11 of the Act. Fortunately, however, the question before the Supreme Court was framed in terms of whether such a power is a judicial or an administrative power. It obfuscates the real issue underlying such nomenclature description as to the scope of such powers, i.e., the scope of arguments which a court, Chief Justice, will consider while deciding whether to appoint an arbitrator or not, i.e., whether the arbitration agreement exists, whether it is null and void, whether it is voidable, etc., and of which these it will leave for the decision of the arbitral tribunal. The nature of such intervention, i.e., would the court, Chief Justice, consider the issue upon a detailed trial and whether the same would be decided finally or be left for the determination of the arbitral tribunal. After a series of cases culminating in the decision of SPP and Company, Mr. Patel and the Supreme Court held the power to appoint an arbitrator on Section 11, the judicial power. The underlying issue, the decision relating to the scope and intervention, was subsequently clarified by Ravindra and Jain and so and so. In relation to the nature of intervention, the exposition of the law is to be found in the District Supreme Court in Shinitsu in the context of Section 45. And the Supreme Court has ruled in favor of looking at the issue's controversy only prima facie. It is in this context that the Commission recommends amendments to Section 8 and 11 of the Arbitration and Conciliation Act. The scope of the judicial entry is only restricted to situations where the court judicial authority finds that the arbitration agreement does not exist or is null and void. Insofar as the nature of intervention is concerned, it is recommended that in the prima arbitration agreement it shall appoint the arbitrator and or refer the arbitration as the case may be. Amendments envisage that the judicial authority shall not refer to the party to arbitration only if it finds that there does not exist an arbitration agreement or that is null and void. If the judicial authority is of the opinion that the prima facie the arbitration agreement exists, then it shall refer the dispute to arbitration and leave the existence of the arbitration agreement to be finally determined by the arbitral tribunal. However, if the judicial authority concludes that the arbitration agreement does not exist, then the conclusion will be final and not prima facie. The amendment also envisages there will be a conclusive determination as to whether the arbitration agreement is null and void. In the event the judicial authority refers the dispute to arbitration and or appoints an arbitrator under Section 8 or 11 respectively, such a decision will be final and non-appealable. An appeal can be maintained only under Section 37 in respect of refusal to appoint arbitration. The difference of statutory language provided in the amended Section 8, which says refer the parties to arbitration unless it finds that prima facie no valid arbitration agreements, in comparison with amended Section 11A, creates disparities which need to be ironed out. While the court in Shinetsu and Judicial recommended finding a valid arbitration agreement on a prima facie qua Section 11, however, under the amended Section 8 for arbitration exists, it is to be noted that the noting of the non-existence of the arbitration agreement is final subject to appeal process only without further scope of arbitral tribunal to decide anything. And let me know for the reference, that be the case in the use of the phrase prima facie stand at odds with established precedents on prima facie standard. In this context, we
Yes.
That's the idea.
Yes, Mr. Advani, yes, we've seen para 239 now. 239 also you see, where they actually refer to fluoro controls.
Right. Whether a multi-party arbitration raises complicated factual questions which are best left for the tribunal to handle. So your lordships, when coming to a conclusion to appoint or not to appoint an arbitrator,
So he knew.
The date of the reference in this matter?
6th May 22.
6th May 22.
The 6th May 2022.
But the SLP of 2020.
2020.
2020. Now, Mr. Advani, anything else?
I just wanted to show you that Ontario judgment of the practical view they take in terms of the UNCTRAL model law, sir.
Why don't you put that in your note, Mr. Advani, now?
I'm happy to do so, but I can point it out to you in 2 minutes. It's only 2 paragraphs, sir.
All
What's
right.
the page numbers?
What's the page in the compilation?
Yes, I'll just give it to you 1 moment. I'll just come. So I don't want to go into too much detail. Page 240 goes into the facts of the case of adding a non-signatory. Then the final conclusion, your lordship will find on page 243.
240 is some, sir, 240 is some judgment of the Ontario Supreme Court.
Yes, Manoj. Yes. Ontario Superior Court, yeah.
Where does it begin actually? It begins at page
235.
237, yes. 237.
And sir, if you go to paragraph 44 on page 243. Legally, as the panel set out in its award, there's ample authority that the model law should be given broad remedial interpretation consistent with the public policy that parties who agree to resolve their disputes by arbitration should be held to that bargain.
Where are you reading, Mr.
Which para?
Mr.
Paragraph 44 on page 243.
So para 37.
Para 44. 45.
Paragraph 44 sir, is the relevant one.
Yes.
Legally.
Legally, as the panel set out in its award, has ample authority that the model law should be given a broad remedial interpretation consistent with the public policy that parties who agree to resolve their disputes by arbitration should be held to that bargain. As the panel noted that none of the cases that Xerox cited to it, which are the same cases cited in this appeal, deal with the interpretation of model law. Admittedly, the same is true of the case of MPI cited panel. Those cases do not support the panel they award to join a parent company where the parties intend to involve them in resolution of disputes arising from a particular contract. Then they go on to the leading case of Dow Chemical. That I don't want to go say. In this case, also, they held a non-signatory as the party, and the court took the broad view that look at the UNCTRAL model law, it will resolve the disputes between the parties, look at the intention of the parties, and then move it on them. And then they made the non-signatory a party, they confirmed that.
All right.
Para 51.
That's just, I'm just saying that because they're dealing with the UNCTRAL law in a broad way, your lordships may consider it in your discussion.
All right. Thank you. Anything else, Mr. Advani?
So may I just, would your lordship like some broad propositions or right at the end? Or may I give a rejoinder, a short rejoinder?
You have your propositions. You have a note or something? You can maybe give us a note tomorrow morning on your proposition.
If your lordship, they're all ready. If I have lordship, may have them emailed to you, I can have them emailed to you.
All right, why don't you send it to the courtmaster? He'll circulate it to all 5 of us.
The advocate on record will email it to you, sir.
Yes, it's ready. It's ready. Just immediately send it to the courtmaster. So that. Mr. Solicitor, would you like to argue at this point? When would you like to argue?
I don't know what time Dr. Singhvi will take. Because
Dr. Singhvi, first of all, who are your
Which
side and what?
Same side and this side. That's why I not get all this side.
That's what I wanted to ask. That's why I asked.
This time the solicitor is also largely on this side, but
I am also largely on that side.
So only.
Sometimes the solicitor and Dr. Singhvi are on the same side.
Yeah, man.
It's a rare, pleasant occasion where he's on the right side.
Factually incorrect, but it was a good one.
Marvelous.
So,
Only
for
difficulty-
other side's perspective, only Mr.
Lord,
Rikin Rai
Your
will
Lord,
answer.
I'll be a little candid, my lords. Your lordships consider continuing tomorrow
Yes, we'll continue because we're now just 25 minutes short of
because
the bails being removed for the day.
I know, lords, there is a group of partners, my lord. Dr. Singh is also there, my lord.
Please wrap it up now. So we have broken up another bench.
I know.
Marvelous. Very good.
I'll be
Yes.
short, my lord, maybe in the second half.
Marvelous. Very briefly, I will go under 2 or 3 broad heads. The first is, Marvelous, I'm very briefly going, the Lordship will pardon us because I don't think we are prepared to the level of a constitutional bench. I said so in the morning. Lordship will put that caveat in front, but we'll try our best. I think most of us were taken by surprise, except Mr. Advani, because we have been a little underprepared. But that doesn't matter. Fools do walk in where angels fear to tread. So perhaps I'm doing that for a constitutional bench. I should be better prepared. But Balas, the first head of my submissions is that this reference may not be necessary at all. And a constitutional bench, Lordship knows, can answer the reference saying no reference arises.
It's divine deja vu.
No, it might save a Lordship's time.
Collection.
Might save a Lordship's time. Second set of submissions is going to be Balas. From the 9, 10, 12 main cases to cull out. And we are not that ready, Balas, in a type.
Dr. Singhvi, we can also give you another option. You can sort of open your case right now, say 10, 15 minutes. And then we'll keep it partnered so that you have a little time to think on the night.
No, I won't finish today, Balas.
Anyway, all right, then
Yes. I'll take about an hour and a half or 2 hours between today and tomorrow.
Then there's no
Because I'm now, because whatever is there, I just want to
Yes.
deal with it.
Then you can't complain that.
No. Because as I said, Balas,
Have the night to do.
I said, Balas, fools do tread where angels fear to tread.
None of us will complain. That was
No complaint, Balas. It's a pleasure to argue here. And whatever is
pleasure.
there, we assist
Not a
also
complaint.
to the best of our ability. It might not be as well prepared as the last 2 constitutional benches I've done, but it will be not too bad, I hope. Now, Balas, the second set of my submission is going to be an attempt to cull out some 10, 12 or 15 principles of why the group doctrine. This is, Balas, after the first point. Your Lordship need not answer the reference at all. In the event Your Lordship answers it, Your Lordship should, Balas, comprehensively reiterate and reinforce the group doctrine for about 15, 16 juristic principles. I'll give Your Lordship those principles as the second head of my submissions. And the third head of my submission is to take Your Lordships quickly through those relevant paras of the 10, 12 judgments, of which Mr. Advani has only cited 3, which bear out those principles. That's far as the broad 3.
The third aspect, Dr. Singhvi?
Third is for us to take Your Lordship through the actual paragraphs. Only some very, very few paragraphs,
Yes.
pinpointing from which those principles can be legitimately said to have a juristic basis, of which I will not repeat. Mr. Advani has dealt with those 2 or 3.
And Dr. Singh, we would also like you to, at the end also, maybe in the night, focus on those contradictions which Justice Suryakant has noticed in the judgment.
Yes.
Because assuming that we are with you,
Yes.
how do you iron out those contradictions?
Yes.
Because Justice Suryakant in his concurring judgment says uphold the doctrine.
Yes.
But a few of those contours, etc., just give them proper shape. That's the other thing.
Yes.
If I may add a fourth one,
Yes.
that will be the last submission, that it will only be a prima facie view of a referring court.
In a section 11
And
situation.
that the arbitral tribunal will thereafter take a decision whether
Yes.
it should be a party or not.
Yes.
Just view on that.
Likewise, Mr. Rai, when you argue, of course, you'll be arguing that there is no group of companies doctrine. We will not stop you from arguing that. But in the manner that you always fairly assist the court, you may also argue on a demurrer that even if you apply the group of companies,
What are its contours?
then how would your contours? So we'd like you to assist us there.
Yes.
As well. Especially because, they are in one side.
Yes.
So we'd like you to.
No, my submissions would be both.
Excellent. Thank you.
Where the group company may find a place in Indian law, and if it does, what are its contours?
Absolutely. That's
I'll
it.
address
Got it. Yes, Doctor.
We have also hard sets made in the course of day to day, but most of it will be Lordship soft copy. If it's not there, then we'll hand a hard set for some cases. Most of it, I think, is with the Lordship soft copy. Now, let's first on the first head. Well, I say with respect that both the learned judges who have formulated, well, A have formulated what might be called grounds.
Both the learned judges
have really given, in particular Justice Suryakant, has given with its grounds, not really issues. I'll just make it good, Manus. Let me give you a point first.
Right.
Two minutes. The issue cannot be, as Justice Suryakant with great respect has formulated, for example, whether this group doctrine can exist in Indian jurisprudence independent of any statutory provision. That's the first issue as formulated. At best or at worst, the issue can be, which I don't think arises really, but can be theoretically, is a group doctrine created by judge-made law barred by the 96 Act?
Exactly.
This question is posing.
Well, judge-made law exists every day. So many things your Lordship says becomes the law, under 141 or 142 especially. Therefore, it doesn't have to be found in a statute. Indian law is statutory, Indian law is common law, Indian law is a Lordship law, Indian law is customary law. So many sources of law. But yes, if the issue is taken to the extreme extent of saying that there is a bar, in some sense of the 96 Act, then a Lordship will look at it and see if there is a bar. Or the other issue could be that your Lordship says Indian judgments, which are not yet a constitution bench, have wrongly brought in the group doctrine. Per se, it is wrong. That's a policy decision, if I may say so, a judicial policy decision of your Lordships. It should not be there. It's a wrong adumbration, it's a wrong importation. Beyond this, I don't think the Constitution bench has any other issue to decide. Behold, these two questions have not been formulated the way I have put it to your Lordships. They have not been formulated. Now, because the rest is ground. Just turn to para 104, page 41 of Cox and Kings, Justice Suryakant's concluding paragraph. Para 104, page 41 of the SCC, whichever compilation Lordship is using.
Difference order?
No, Justice Suryakant's, yes, the judgment, which is in Cox and Kings, which my lord had read in full.
We are reading from the court's order.
Yes. No, the conclusion, para 104 is the conclusion of my lord's judgment.
Page 903.
Oh, my lord is using unreported.
903.
48.
Oh, I'm sorry. That might be compilation page, para 48 page.
This is the fourth judge.
That will be page 66.
Para 48. Whichever way, I was using the SCC. Now, the first issue at 104.1, or rather A issue A, capital A. Does my lord have it? My lord has got it. Justice Roy has got it.
Page 928. Page 928.
Justice Padiwala. Whether the group of companies doctrine should be read into Section 8 of the Act, or whether it can exist in Indian jurisprudence independent of any statutory provision. Because it already existed before. It is existing. The Law Commission tried to clarify it. Suppose, Balus, there was no amendment to it. The only question then would be that is your lordship wrong in adumbrating a group doctrine, or should it be there in Indian corporate law, arbitration law? Because theoretically, this issue is really not arising and would not arise in a situation. I'm assuming that 8 is not amended. Your lordship makes declaratory amendments, codificatory amendments in the legislature. Second issue is whether the group of companies doctrine should continue to be invoked on the basis of a principle of single economic reality. That's what is actually a ground. If the group of companies doctrine can have many juristic bases, I'm going to give your lordship 15 odd bases for that. One of those bases is single economic reality. Now, is there a juristic basis correct or not? Of course, your lordship can opine on it. But it is clearly there in a lot of case law. Third is whether group of companies doctrine should be construed as a means of interpreting the implied consent or intent to arbitrate between the parties. That's either a ground or a conclusion. Your lordship really cannot decide it in this form. Actually, both fellows implied consent or intent to arbitrate.
Reformulate.
Yes.
We'll put it to you that this is how it could be reformulated.
Yes.
In the Arbitration Act,
Yes.
reading section 7 with 2H,
Yes.
is it not the intendment of the Parliament that only parties who are signatories to the agreement will alone be entitled to? It does not enable, by implication, bringing a party who is not a part of the contract.
I'm grateful. That's really because your lordship is making it narrow and make it wider against me. It's what I said at the beginning. Does the 96 Act not permit the declaration of a group entity doctrine? Whether 2H does not or 7 does not, does the Act inhibit?
No,
It can only be a bar.
Statutory statute's own expression.
Yes.
Does it permit anybody other than a party to the contract?
Very well. That's the positive way of putting it or negative way. Either.
When I was typing, I took down your first submission as.
Yes. It's the same thing.
When you said both the learned judges have furnished grounds and not issues. The
Yes.
first point which I took down was, is the group of companies doctrine concept which is created by judge-made law barred by the 1990s?
Barred. Now you can play different words. Don't use barred.
The other is saying barred specifically by
Permitted.
218H
Permitted.
section 6.
But the only thing with permitted is one. Suppose it is not explicitly permitted. Suppose, I'm not saying.
It may not be barred accordingly.
Exactly. It will not prevent your lordship from enumerating it. Your lordship does it every day.
But it's not, no, you know, that's not the...
Does not contemplate. Your lordship uses more to contemplate.
It is not explicitly permitted. But could we be reading, could section 7 be read so as to exclude anything but a written agreement?
So does the 96 Act not contemplate that a person who is not a signatory can be... That's a better way. No problem.
That's the point.
Note down all this. Does the 96 Act contemplate a person not a signatory to be part of an arbitration process? I'll formulate it more clearly with this for tomorrow, but that's barred maybe too extreme, permitted maybe affirmative, or should we take a middle view?
This we put it to him so that you can reflect on it in the context that agreement can be implied under the general law of contract and arbitration. Number 2, arbitration is specifically a matter of contract between the parties.
Implied consent
It's
is
not a public law. It's not a public.
Implied consent is one of the basis, juristic basis of the 15
I'm
basis.
just putting it to you.
Yes. So, Malas, that would be one issue. The other would be a larger issue I'm putting against myself. That does your lordship as a constitution bench think it fit that there should at all be a concept in Indian law called group of doctrine? I mean, group of companies doctrine. Namely, that all the judgments are wrong, which have adumbrated it. The judgment should not have adumbrated it. I mean, it's the same thing overlapping, but it's a larger issue. That judicial policy of your lordship does not contemplate because it's highly unjust, it's highly oppressive, it's unnecessary, it is productive of mischief. Whatever your lordship is, that's your lordship judicial policy. That's really only the issues arising according to me. You can put it in different ways, Balus. These are, now see number 4, Balus, D. It's one of the grounds, Balus. They're all bases. Piercing the veil, alter ego. These are all bases, Balus. Now let us turn to Balus justice.
What we'll do is, we'll rise right now.
Yes.
That you have a little time to reflect.
Yes.
You know always how you formulate, Sometimes your number 7 is our number 8 or point number 6 is our number 5.
When I oralize it, when I write it down.
I know that's right. It's on a lighter vein, Dr. English. So we'll give you, so then tomorrow morning you will have, you'll have the whole evening to reflect and then. And then Mr. Solicitor will like it too. So it's a very important central act. This will have a bearing on the very course of Indian arbitration.
But I have.
So we are happy that you are intervening because as the Parliament having.
After my lord's decision.
No, we were suggesting that why is it that the Law Commission's recommendation was not followed? Just check it up.
Just check that. I have already requested the Law Secretary that you give me entire details, whether it was considered, whether it was a conscious decision
or just a casus almost.
I have one request, my lord. I'm in Article 501.2, item 501.2. After my learned senior's complete, I may give you 15 minutes to make my submission.
Of course.
Give your best.
That is just.
May I also find a compilation?
And if you can give us a short note of 2 pages, it's always better because then it becomes focus.
Yeah?
2.5.
We'll also circulate whatever we made in the email soft copy.
Certainly. Mr. Rai, your note is.
Obliged.